Welcome back, Council. We will return now to the claimants for purposes of receiving some answers to the earlier tribunal questions. In the meantime, though, I want to make sure that someone from respondents' team is trying to address what I understand to be an issue with the receipt or download of the PowerPoint. I've received a note from Ms. Peters, the English court reporter, that she can't access the document. And I mentioned this to one of your team members. I will say that I have finally been able to access it, but only by going through about 4 steps to first download your firm's software, set up an account, set up a password, wait for a confirming email. It's not the most efficient way of doing it when we only have 5 minutes to do it. So for future expert presentations and so forth, perhaps just an email would be simplest. But in any event, if someone could get it to Ms. Peters while we're addressing this, I'd appreciate it. Okay. Please proceed.
Thank you, Madam President. Just first, before turning the floor to Ms. Zayeva to provide the responses, I would simply note for Professor Stern that the Free Trade Agreement in Article 805.2 specifically states that denial of justice applies to administrative proceedings. But that doesn't mean we can't continue the debate on the topic. With that, I'll turn the floor to Ms. Zayeva.
Thank you. Madam President, Professor Hanatia, with respect to your question about the nature of the individuals or groups that we're discussing, allow me to please clarify the distinction between the traditional and illegal mining. Professor Guiza will provide a detailed response next week for each categories of these miners under Colombian law, but I would like to just briefly explain the difference to address your question. So first, under Colombian law, traditional miners are those carrying out mining works continuously over a period of time and who are able to demonstrate that they have been present in the mining area for no less than 10 years, counted from the date of the enactment of particular mining laws. I refer you to Exhibit R110, which is Law 1382 of 2010, and Exhibit AM65, which is Law 2250 of 2022 for these definitions. It is important to note that the law provides special protections for those who are traditional miners. Therefore, it is not termed that the miners can just apply for themselves. They need to get a recognition given specifically by the authorities. It functions similarly to, for instance, disability law in the United States. In order to receive the benefits, a person needs to prove they fit the legal definition. So if a miner comes from a community that has a long history of mining, does not automatically mean that he's a traditional miner under Colombian law. So Colombian government specifically enacted this law to grant protections only to those who can prove they fulfill these requirements. And there's no evidence on the record that any of the miners present in GCM's titles without GCM's permissions have obtained this recognition.
Before you move on
yes.
to any other categories, I've heard the phrase artisanal mining. Is that the same or different than traditional mining or small-scale mining?
This is something that Professor Guiza will explain,
Okay.
but for the purposes of Colombian law, there's no specific distinction. Decree 1666 of 2016 provides a classification of small, medium, and large-scale miners, and this is based on two things. One, the volume of their production, and two, the number of hectares in their mining title. So these terms are simply descriptions of the type of mining enterprise. For definition, I refer you to Exhibit CL288. Illegal miners are those who conduct mining activities without a title and without a permission of a title holder. They can be small, they can be medium, they can be large scale. They can come from communities with historical ties to mining activities. But unless the state formally recognized them as traditional miners, as I just described a minute ago, they're just illegal miners. I refer you to paragraphs 18 through 44 of Professor Guisa's report and to paragraphs 50 to 61 of claimant's reply for more detailed explanation. And finally, Professor Anatio, you are correct that there is an instance when a person can mine legally without permit. There are those qualifying as subsistence miners. I refer you to Exhibit LG14 for the definition, but their production, as we discussed this morning, must be extremely small. It cannot exceed 35 grams per month, and they cannot use mechanized equipment or mine underground. None of the miners GCM once removed from its titles have ever qualified as subsistence miners. And none of the illegal miners on GCM's property have titles, nor have they been designated or formalized as traditional or other protected categories of miners by any governmental agency. Most of them do not even qualify as any of the categories of small-scale, artisanal or ancestral miners. Accordingly, they can only be categorized under law as illegal miners. Professor Stern, with respect to your question, there are differences in the facts in South American silver and this case. In that case, the claimant acquired a concession for mining blocks in an area that was almost entirely populated by 2 indigenous communities. During the drilling activities in 2010, the claimant polluted the community's sacred places. Employees of the company raped several local women, and when the communities proclaimed that the investor sees all mining activities due to its disrespect of the communities, the investor's response effectively was, as it says in the document, they only raped 4 out of 8, and actually they were not rapes at all. The community was understandably incensed, and in the spring of 2012, the community engaged in several actions in protest. They abducted the investor's employees and police officer, attacked a drilling rig, marched on the Capitol, and blocked off access to the project. When the police intervened in that case, 13 people were injured in violent clashes and a community member died. GCM has not committed any acts against the local community. There's also no evidence of the opposition of an entire community as a result of such acts. There's only evidence of opposition by illegal miners. There's also no evidence that a police intervention would result in the same level of violence as it did in the case of Bolivia. There's no indication of marches on the Capitol organized by Segovian or Marmato communities, no abductions, and certainly no death. Therefore, there's no evidence that a state intervention would be an inadequate measure to resolve GCM's problems with illegal miners. Further, while the ILO did say that the use of physical security against miners can lead to violation of human rights, that is not necessarily the case. In Colombia, military interventions are accompanied by representatives from other agencies, such as Attorney General's office, who are there to ensure that precisely such violations do not occur. The military and police also receive extensive training, as far as we know, regarding human rights, and there's no evidence that what the ILO is concerned about would occur. Further, GCM is not asking for mass evictions or militarization of Segovia or Marmato. For instance, Segovia already has police officers and military personnel. GCM is only asking for this personnel to also protect GCM's investment and not just illegal miners. I would also like to note that even with all these horrific findings against the investors, the tribunal did find that Bolivia's action constituted an expropriation that entitled claimant to lawful compensation. Finally, Madam President, with respect to your question, the quotes that you've heard from me this morning were made at the time of the investment, but indeed there is no witness on the record that says that he saw that those statements were made at the time. Thank you.
Thank you. Let me just ask my colleagues whether you had any follow-up questions for the claimants. No. All right, in that case, we are ready, I believe, to begin with the respondent's opening. Let me just confirm whether the court reporter has received the document now that you need it. Okay. Are you comfortable proceeding without it, or? Okay. All right, then let us proceed.
Thank you, Madam President. Thank you, members of the tribunal. The present arbitration, and I will organize this opening in the following way. I will make a general introduction with an overview of the case and put in some context. It will take me no more than probably 15 to 20 minutes. And then we will go direct into the PowerPoint presentation. But before that, taking the advantage that we have Ana Maria Ordóñez from the Agencia present here at the hearing, the Agencia would like to address the tribunal for a few minutes. So, Ana Maria, please.
Thank you. Dear Madam President and members of the tribunal, as the Director of International Litigation at the National Agency for the Legal Defense of Colombia, it is an honor for me to appear before this tribunal. This investment arbitration will allow you to understand the complex social and economic reality around gold mining in Segovia and Marmato. As a sovereign state's representative, I will address you in Spanish. Colombia, oh, sorry. Colombia incluyó capítulos de inversión en tratados de libre comercio como el celebrado con Canadá, con la intención de promover la inversión extranjera como parte de una agenda de crecimiento y desarrollo. Y ese objetivo se ha cumplido. En el 2021, Colombia se registró como el cuarto destino de inversión directa más grande de inversionistas canadienses en Centro y Suramérica. Y es por esto que las inversiones de GCM, como la de cualquier inversionista, son bienvenidas en Colombia. En la actualidad, GCM tiene una operación altamente rentable en el país y Colombia percibe regalías por ello. A diferencia de la mayoría de disputas sometidas a arbitraje de inversión, este no es un caso de un inversionista desposeído de su inversión, sino de uno exitoso y con una operación altamente rentable. De hecho, GCM, demandante en este arbitraje, es el principal explotador de oro y plata en el país. ¿Por qué estamos entonces aquí? Porque GCM está usando este foro como una suerte de póliza de seguro para reclamar el reembolso de ciertos costos que eran esperados y previsibles y que son la consecuencia lógica de sus actividades y de la realidad histórica de la zona geográfica en donde invirtió, los municipios de Segovia y Marmato. En efecto, en relación con Segovia, la demandante alega que Colombia violó el estándar mínimo de trato del TLC por no haber ejecutado los centenares de amparos administrativos presentados contra miles de mineros informales que trabajan en sus títulos desde hace años e incluso décadas antes de que GCM realizara su inversión. Respecto a Marmato, GCM asegura que Colombia violó el estándar mínimo de trato y además expropió la inversión. GCM alega haber perdido sus títulos de la zona alta del Cerro El Burro debido a la falta de ejecución de los amparos administrativos presentados por la compañía contra centenares de mineros informales. También alegan que la sentencia SU 133 de la Corte Constitucional Colombiana supuestamente cambió las reglas de juego en materia de consulta previa aplicables a su inversión al exigir un proceso de consulta con la comunidad. Como verán en el transcurso de los próximos días, todos y cada uno de los hechos y circunstancias que sirven de base a las reclamaciones de GCM existían desde antes de que invirtiera en Colombia. Se trataba de los riesgos asociados a una inversión rentable que era razonablemente posible prever y que se debían gestionar adecuadamente. Es un hecho notorio e incuestionable que Segovia y Marmato son municipios con fuertes tradiciones mineras que datan de varios siglos. De hecho, el casco urbano de estos municipios está ubicado sobre el subsuelo de los títulos mineros de GCM. Es decir, las poblaciones de Segovia y Marmato han vivido y trabajado literalmente encima de los títulos mineros adquiridos por GCM, los cuales, recordemos, confieren derechos únicamente respecto del subsuelo. La cultura e historia de ambos municipios está inexorablemente ligada a la minería y por ello la población local considera tener derecho a explotar el subsuelo de donde viven. Ante este panorama, cualquier inversionista medianamente diligente pudo haber advertido sin mayores dificultades que, para el desarrollo exitoso de cualquier proyecto, habría tenido que establecer relaciones positivas con la comunidad y que sería prácticamente imposible e incluso altamente contraproducente desalojarla por la fuerza. La tensión entre el derecho que tiene GCM a explotar la totalidad del área de sus títulos mineros y la realidad de la minería informal en Segovia estuvo aplacada durante muchos años por la decisión de Frontino, empresa antecesora de GCM, de tolerar la minería informal siempre y cuando no interfiriera con las operaciones de la compañía en sus minas activas. En Marmato, la repartición del recurso minero de la zona alta del Cerro El Burro para los pequeños mineros y la zona baja para las empresas industriales permitió una coexistencia entre los dos tipos de minería que perduró durante décadas. Esa era la situación imperante al momento en que GCM adquirió los títulos objeto de este arbitraje. En 2010, la llegada de GCM a estas comunidades rompió con estos finos y delicados equilibrios. En Segovia, GCM adoptó una estrategia ambivalente al prometer la formalización de los mineros informales, mientras que a la vez solicitaba el desalojo de los mismos mediante la presentación desbordada de amparos administrativos. En Marmato, GCM cerró y abandonó las minas que había comprado individualmente a los pequeños mineros con y sin título, dejándolos sin ninguna alternativa de sustento a largo plazo, y anunció que desarrollaría un proyecto de minería a cielo abierto que requeriría la reubicación de todo el pueblo. Como era de esperarse, las comunidades de Segovia y Marmato reaccionaron negativamente a las propuestas de GCM. En este arbitraje, GCM acusa a Colombia de no haber hecho lo que debe y puede hacer para desalojar a los mineros informales de sus títulos mineros. Como ejemplo de lo que Colombia supuestamente debe y puede hacer, GCM se refiere a la denominada Operación Creta, un operativo de policía con acompañamiento del Ejército Nacional para combatir la minería ilegal en el municipio de Buriticá, en el departamento de Antioquia. Sin embargo, como también oirán en el transcurso de esta audiencia, las circunstancias históricas, sociales, económicas y de orden público de Buriticá son completamente diferentes a las de Segovia y Marmato, por lo cual un operativo de este estilo en dichos municipios sería completamente inapropiado, inefectivo y contraproducente. La Operación Creta fue un operativo excepcional para enfrentar una situación social y de orden público igualmente excepcional y súbita. La llegada de miles de buscadores de oro al municipio detrás de la fiebre del oro, el consiguiente colapso de la capacidad institucional del municipio para recibirlos y el control por parte de la organización criminal denominada Clan del Golfo de dicha explotación minera ilegal. Ninguna de las anteriores circunstancias está presente en los municipios de Segovia y Marmato. Esta mañana el tribunal escuchó a la demandante hablar de todas las supuestas fallas y omisiones en las que las autoridades colombianas han incurrido al dejar de proteger los derechos de GCM. Sin embargo, y lo sugiero de manera respetuosa, las preguntas que el tribunal debe hacerse para decidir este caso consisten en realidad en determinar primero desde cuándo existen dichas circunstancias y segundo, si la demandante sabía o podía razonablemente saber de ellas. Adicionalmente, el tribunal deberá determinar también si, bajo las circunstancias, las autoridades colombianas han actuado de forma legítima y razonable. Como oirán de nuestros abogados, ninguna de estas situaciones es nueva. GCM sabía o debía saber de ellas antes de invertir en Colombia y es imposible que las autoridades se comportaran de otra forma respecto a las mismas. Con la venia de la Presidenta, cedo la palabra al equipo de Latham & Watkins, liderado por Fernando Mantilla Serrano, para que continúen con la presentación de nuestros alegatos. Muchas gracias.
Thank you, Ana Maria. As the representative of Colombia mentioned before, the present arbitration, Madam President, members of the tribunal, turns around facts and circumstances that predate GMC's decision to invest in Colombia and to acquire the mining titles of Segovia and Marmato. These regions, Segovia and Marmato, suffered for decades of an endemic, and I underline endemic, proliferation of informal mining, mostly carried out by artisanal and small-scale miners, the famous ASMs, that we will continue to refer to with the acronym. The record demonstrates that GCM chose to invest knowing full well of this reality. In order to address the issue of illegal mining, Colombia has made a reasonable and non-discriminatory policy decision that is supported by international organizations and the mining industry at large. Indeed, Colombia has had a consistent approach over the years based on two premises. First, to foster formalization through dialogue and consensus. And second, not to use force to evict the miners. In implementing this approach, Colombia, which is the longest-lasting democracy in Latin America with solid and respected institutions, including an independent judiciary, has acted in full respect of international law and in application of its constitution under the strict supervision of its constitutional court, very highly respected constitutional court. GCM suggests that Colombia should have to use all of the state force, including the army, in order to evict illegal miners. In so doing, GCM invites this tribunal to second-guess legitimate policy decisions by Colombia without adducing any evidence that such a forceful eviction of the miners could have yielded a different and better result. International law cannot be exploited to compensate investors for risk that they voluntarily assume. Members of the tribunal, GCM's claims is a classic attempt by an investor to blame the state for the consequences of his own business decision. When GCM decided to invest at Segovia and Marmato, the singular risk it agreed to assume was the risk associated with the presence of ASMs within the title areas. GCM took on that risk and created a business model which from the very outset factored in dealing with ASMs one way or another. GCM believed it could make money at Segovia by contracting with ASMs. And GCM believed it could make money at Marmato by paying the ASMs to relocate so that their town could be turned into an open pit mine. GM succeeded in his plan to contract with thousands of ASMs in Segovia. Those contracts have been hugely profitable to GCM. But GCM failed to enter into contracts with others than Segovia. And his plan to pay off the ASMs at Marmato also failed. So GCM now turns to this tribunal looking for compensation as a result. The tribunal should dismiss the claim because GCM cannot use the free trade agreement as an insurance policy, as Ms. Ordóñez has mentioned, against risks that it chose to take when it invested. Mining, members of the tribunal, is a risky business at any time, in any place. To succeed in a mining project, a mining company must find sufficient mineral resources in the ground, find a technically and financially viable way of extracting those resources, and secure a number of legal rights, permits, and titles from the government. But most fundamentally, to succeed, a mining project must gain the acceptance of the local community. That acceptance by the local community is known in the industry as the social license to operate, SLO. Without the acceptance of the community, a project is bound to be disrupted and may not even be able to proceed at all. Where, like in Segovia and Marmato, the local community's livelihood depends on artisanal and small-scale mining, a mining company will inevitably need to find a way of working with that community that is acceptable to that community. GCM knew that. Outside of this arbitration, it has repeatedly made statements confirming that working with ASMs is part of the social license to operate. But in this arbitration, GCM says that because the social license to operate isn't a legal requirement, the tribunal should proceed on the fiction that the ASMs can be ignored and should have been removed by the government by force. That position is disingenuous and inconsistent with GCM's own stated commitments to operate in accordance with international practice and standards of corporate social responsibility. Since at least the late 1990s, international organizations, states, and the mining industry alike have recognized that mining companies must meet the needs of communities on which they operate, whatever those may be. Building schools and hospitals may be necessary, but it's not sufficient. Where the community holds a strong belief that it should be allowed to continue to earn its own livelihood through mining, like is the situation in Segovia and Marmato. In those circumstances, international organizations of states, the mining industry, and Colombia's law all make clear that there is only way for a sustainable solution, formalization. This is the only sustainable and appropriate model for places like Segovia and Marmato because it allows the mining company to pursue its large-scale project with the acceptance of the community while providing the local community with employment. GCM itself has touted this model in his literature and conference around the world. Unsurprisingly, international organizations like the International Labour Organization and the World Bank recommend this model to states. These organizations have urged states to seek to foster the formalization of ASMs in their integration into large-scale mining projects rather than the use of force to displace or criminalize ASMs. From a large-scale miner's perspective, implementing the contractor model can be hugely profitable. And indeed, GCM has made a very substantial proportion of its profits through the work of ASMs from the very outset of its operations. But unsurprisingly, this model comes with risks. The model requires the mining company to approach its relations and negotiations with ASMs with care and to offer fair and acceptable terms to ASMs. There will invariably be conflicting interests between large-scale miners and ASMs, especially where ASMs are organized in different groupings and may have different demands. But managing that risk and coming to agreements with those different groups is precisely the challenge and the risk that GCM chose to take on. Where ASMs have been established in an area for generations and are organized in associations, the large-scale mining company will, of course, need to offer sufficient economic incentives.
Can I jump in and
Sure.
Put to you the same question I put to the claimant, and if you prefer to return to it later, that's fine as well. But I'm struggling with the same issue. The tribunal's been presented with a factual dispute about whether the miners who are currently operating within the tidal area are in fact ASMs, long-term families operating on a small basis, or outsiders operating on a more industrial basis. There's a factual dispute before us. So the questions are, how are we to resolve that factual dispute? And secondarily, if the conclusion is there are some of both, two things can be true at once, what do we do with that? Do we have the same ruling with respect to the two different groups, or do you suggest that we distinguish? What do we do with that?
Thank you, Madam President. We will address that point later on, but allow me to tell you something. The situation, I mean, as you may imagine, with illegal miners is that they don't have IDs saying I am illegal or saying I am a small-scale miner. So there is a little bit of both, and that's a reality. I mean, has been historical situation in Marmato and Segovia. And the Colombian does not deny that there are some criminal groups also involved. So that's a reality. The issue here is that when we talk about MS, we are not talking, as seems to have been the impression given by the claimant in the presentation, about only individuals. Those individuals may get associated among themselves. And the fact that they are numerous and that they exploit huge amounts of mineral that do not render them large-scale miners. And that, I think, is an important point. But we will come later on in this regard. So I would say that many, and this is a good link to my presentation, many of the SMS at Segovia, such as the El Cogote Association, and this is a good example, El Cogote Association, for example, held firm beliefs that they had a right to mine there. El Cogote Association had been there for at least 40 years, and is an association of small-scale miners. Of course, being associated for many years, they have an infrastructure that could give the impression that it's a large-scale mining as a whole, but it's just an association of small-scale miners. They were on a 10-year contract with Frontino when GCM arrived. And so it obviously came as no surprise to GCM that the El Cogote miners didn't simply pick up their tools and leave when their existing contract came to an end in 2013. Nor could GCM have been surprised that the government didn't send in the army, or that the local authorities elected by local communities of ASMs didn't send in the police to evict the ASMs whenever GCM filed an amparo. You heard GCM this morning insist that Colombian law granted it exclusive rights to mine in the area, and that the government didn't follow domestic law in failing to enforce the barrage of amparos GCM filed. That complaint, which is at the core of GCM's case, could not be more disingenuous. The record shows that GCM knew, or certainly ought to have known, through due diligence, that ASMs were there from the start. GCM also knew that they weren't just going to leave or accept any terms proposed by GCM, and that the government's policy was to seek to foster their formalization and not to evict them. At Segovia, GCM entered into dozens of contracts with ASMs under terms very profitable to GCM. But GCM failed to gain the acceptance of other ASMs because GCM insisted on seeking to impose its terms. For example, GCM insisted that the contracts be short-term one-year contracts that could be terminated by GCM at any time and without cause, giving GCM flexibility while providing the ASMs no long-term security. Unsurprisingly, many of the ASMs did not accept this and preferred to continue working independently. When GCM's attempts to evict them flared up, they went on a strike and disrupted GCM's operations. Where that happened, the government stepped in to protect GCM and mediated a solution. Yet, remarkably, GCM in this arbitration tries to blame the government for strikes and claim damages. That was the situation in Segovia. At Marmato, GCM says it hasn't been able to agree any contracts. Well, that's not surprising, given that GCM went in and immediately said it would be pursuing an open pit project that would require the destruction of the town and removal of all ASMs. GCM tried to buy the people out and pay them to leave. That failed. And GCM alone is responsible for that. Ultimately, GCM decided to abandon that project in 2013 in light of the social opposition it created and tumbling gold prices. It is not surprising that those GCM had displaced returned. GCM is now responsible for failing to develop any operations there that integrated them. GCM also says that ASMs are not members of the local communities, but are criminals or invaders. But the record does not bear that out. The overwhelming majority of the informal miners in these communities are locals. And yes, as I mentioned before, there are criminal groups at Segovia and Marmato. But criminal groups have operated there for a long time long before GCM arrived. Colombia is committed to eradicating such groups wherever possible. But while there may be links between some ASMS and criminal groups, the ASMS are the victims of those groups. Colombia's authorities have, of course, been tackling criminality with the means available to them, including targeted military operations, where there is evidence warranting such operations. Similarly, while some ASMs may have migrated to Segovia and Marmato over time, that couldn't have come as a surprise to GCM either. Like in many other cases and areas in Colombia, populations of ASMS ebb and flow over time. And the arrival of new ASMS, known as influx ASMs, are also an inherent risk in any mining project to be handled by a mining company. This tells the tribunal all it needs to know about GCM. His entire case has been about trying to turn his own bad business decisions on their head and blaming Colombia for them. And that is, of course, not something international law allows. Under the FTA, Colombia undertook to treat Canadian investors in accordance with customary international law minimum standard of treatment. That standard does not require Colombia to compensate GCM for the materialization of known and voluntarily assumed risks. There is nothing shocking or egregious in Colombia's decision to encourage formalization, rather than to carry out mass evictions in response to barrages of amparos filed by GCM in the complex circumstances of Segovia and Marmato. Colombia's policy was never to conduct mass evictions at Segovia and Marmato. GCM knew this when it invested. Nothing changed over the course of GCM's investment. GCM says that Colombia's inaction at Marmato, coupled with judgment SU 133 of the Constitutional Court protecting the rights of the local communities and indigenous people to a consultation, amounts to an expropriation. This is a shamelessly opportunistic claim. GCM's failed open pit project at Marmato had been shelved since 2013, and the 2017 SU 133 court decision should have come as a no surprise given the circumstances at Marmato, and clearly hasn't taken the value of GCM's investment away in any event. For these reasons, among others which we will develop during the presentation, the tribunal should dismiss all these claims. With respect to the PowerPoint presentation, Madam President and members of the tribunal, it will be structured as follows.
Do we have this?
Yes.
So I will continue while you get the slides. There will be three parts. First, Mr. Romero and I will address why the claims are based on fundamental mischaracterizations of facts. We will show that ASMs were always a reality of doing business at Segovia and Marmato, and that GCM is responsible for his own failure to gain the acceptance of ASMS there. We will also address why GCM's opportunistic attempt to relitigate judgment SU 133 in this arbitration is misguided, and why it is not the case that GCM has been deprived of its rights in the so-called affected area at Marmato as a result of the ongoing consultation ordered by the Constitutional Court. Second part will be addressed by Mr. Pape, and will address why the claims fail under the treaty standards and international law. He will explain that the risk associated with ASMs was assumed by GCM as one of its core business risks, and as a matter of principle, the FTA is not an insurance policy against such risk. He will then address why, particularly in light of that principle, GCM's claims fail under the customary international law minimum standard of treatment, and why GCM's Marmato expropriation claim fares no better as a matter of law. Finally, also Mr. Pape will address why, if the tribunal were to get to damages, and we hope you will not have to address them, it should dismiss each of GCM's damages claims as flawed, speculative, and in any event, grossly exaggerated. Members of the tribunal, I will start by addressing the facts. You heard GCM this morning say that the miners who operate at Segovia and Marmato without a title are variously illegal miners, invaders, and criminals. The reality is that these people are like millions of others around the world, most accurately described as ASMs. And they are simply a reality of doing business in places like Segovia and Marmato. To see why, I will start by explaining what ASMs are and will take the tribunal through some of the evidence showing that they are a common feature of the mining industry in many parts of the world, and that there is a consensus between international organizations and the mining industry that ASMs should be formalized and not criminalized. I will also show that here, GCM invested at Segovia and Marmato, knowing that the ASMs were there and would need to form part of its business plans. First, some important context. There are millions of ASMs in the world, including hundreds of thousands of them in Colombia. We have set out on the slide a map prepared in 2008 by the World Bank, the IFC, and the International Council of Mining and Metals, the ICMM, which confirms that ASMs exist in nearly all emerging economies. The map shows an estimated 150,000 to 300,000 ASMs operating in Colombia in 2008. Other research from the 1990s and early 2000s on the record confirms that ASMs operate all over the world, and that this was certainly well documented before GCM came to invest in Colombia. For example, International Institute for Environment and Development published a report in 2002 with data on ASMs per country. The table in the top right side of this slide shows the estimated numbers of ASMs in various parts of Africa, South America, and Asia. In Colombia, between 2010 and 2011, the Colombian Ministry of Mines carried out a mining census and found that more than 70% of the mines in Colombia are operated by small-scale miners, and that small mining units tended not to have mining titles. Now, we would invite the tribunal to read the report called Working Together, prepared by the World Bank, the IFC, and the ICMM in 2008, Exhibit R126. This report was prepared by international organizations in conjunction with the mining industry, represented by the ICMM. GCM is, of course, an indirect member of the ICMM, since GCM is a member of the Colombian Mining Association that in turn belongs to the ICMM, or is a member of ICMM. In addition to identifying the presence of ASMs around the world, as we saw on the previous slide, this report found that the presence of ASMs in the mining industry was well recognized by large-scale mining companies and governments. Importantly, the report explains that the fact that ASMs do not hold legal title and are therefore illegal is not a reason for large-scale mining companies and governments to treat ASMs like criminals. To the contrary, the report urges large-scale miners to help them regularize their operations and for governments to encourage their formalization. Formalization is well understood in the mining industry. It is the process allowing informal miners to move towards the legal or formal economy. The formalization process usually entails the registration of the miner and their activities with the national authorities. Formalization will also grant to the formalized miner the same rights as other formal miners. And formalization also establishes obligations for formalized miners, such as the payment of taxes and royalties on miners' production. As part of its communities and small-scale mining initiative known as the CASM, the World Bank and the IFC issued a second report on the relations between large-scale miners and small-scale miners in 2009 called Mining Together. An excerpt of this report, produced as Exhibit R128, is on the slide. In this report, the World Bank and the IFC established a series of guiding principles that the large-scale miners should follow in order to engage with ASMs. The report also proposed a list of actions to be taken in order to guarantee beneficial relations between large-scale miners and ASMs. One of the categories of actions proposed in the report concerns formalization. The report distinguishes between different scenarios which large-scale miners may face and notes that small-scale miners may sometimes be well-established and organized. It notes that where artisanal and small-scale mining has been present for a long time and the miners have been able to get well-organized, and I quote, "It is likely that the community's sense of ownership upon mineral resources is high. A formal agreement to cohabitate and share the resources is probably to be sought." As we will come on to in a moment, it is not disputed that there were organized, well-established, long-standing ASMs at Segovia and Marmato when GCM chose to invest there. Now, as the title suggests, what the Working Together report certainly does not recommend is the use of force against small-scale miners. And this is consistent with the International Labor Organization's analysis too. The tribunal will find at Exhibit R123 a report from 1999 published by the ILO following a tripartite meeting and research mission between the ILO, representatives from 18 countries, including Colombia, and representatives from the mining industry and small-scale miners. The report considered that the only viable and sustained approach to be taken by the states and large-scale mining companies was institutional cooperation. The tribunal will see on the slide the matrix of different approaches. The institutional cooperation approach, in which the government develops positive policies in conjunction with the mining company and small-scale miners, and the company and the small-scale miners develop a positive relationship, is likely to result in a positive outcome involving lasting peace and the development of the area around the mine. In contrast, and highlighted in yellow, at the other end of the spectrum, where large-scale mining companies seek to evict small-scale miners from their property. This results in conflict and leads the small-scale miners to react against the mining company regardless of what the government tries to do. Now, the ILO is not naive. It makes clear in his report that many small-scale miners may not be interested in being stifled by a large-scale mine. That's why the ILO notes that, I quote, "care is needed in establishing and maintaining the right kind of relationship between small miners and large-scale mining companies." It concludes that close collaboration between large and small mines will be good for mining, good for the company concerned, and good for the small-scale miners. This brings us to a term that you will be hearing a lot about these next few days, and you have heard about it already, which is social license to operate, SLO. What is it, and why is it at the core of this dispute? The tribunal has on the record a number of sources from the literature on social licensing. We have set out some excerpts from some of them on the slide. This notion was originally coined by Robert Boutelier and Ian Thompson, consultants in stakeholder relations, and is widely accepted in the mining industry today. In short, a social license to operate is a community's perceptions of the acceptability of a company and its local operations. It is the idea that a mining company cannot operate in a vacuum and simply conduct his operations in compliance with the law without regard to his impacts on the surrounding community. Without the acceptance of the communities, a mining company may seek its project brought to a halt, even though the company may have all the necessary titles and permits required to mine. And so the literature tells us that the social license to operate is not a document or a permit granted by the government. Rather, is an unwritten social contract granted by the neighboring local communities and stakeholders impacted by the mining project. It is both intangible and non-permanent. And this is important, non-permanent. It needs to be maintained continuously through every decision and action of mining company that has an impact on the community. For this reason, the social license to operate is an active part of the operating strategy and management of any diligent mining operator. International mining companies have adopted this notion in their strategies and risk analysis. You will hear from Bernardo Elizalde and Natalia Gonzalez. Natalia is today in the room, Colombia's experts in the field of social licensing and small-scale mining. They routinely act as consultants to mining companies and have conducted research on this field, including in Colombia. They explain, based on their experience and the literature on the subject, that it is now well understood by mining companies that they must develop positive relations with ASMs in order to earn their SLO, social license to operate, and not seek their eviction through force. They will explain this further in their presentation to the tribunal next week. GCM's case is that this is all well and good, but that it was under no legal obligation to have any regard for the ASMs at Segovia and Marmato because Colombia granted GCM the exclusive right to mine there. But outside of this arbitration, GCM claims that it is committed to conduct his business in accordance with good international practice aligned with the views of the ILO, the IFC, and other organizations. The tribunal will find at Exhibit PB25 the sustainability policy adopted by GCM's Board of Directors in 2013 and most recently amended in 2021. The policy commits GCM to develop and maintain ethical and responsible business practices that includes complying with all applicable environmental, health, and safety laws, regulations, and standards, and also to seek to comply with good international practice. The tribunal will have seen a number of relevant guidelines and principles prepared by international organizations, including the mining industry itself, codifying how mining companies are to conduct their affairs in light of their impacts on local communities. The OECD guidelines for multinational enterprises, for instance, note that enterprises should take fully into account established policy in the countries in which they operate. And so it is not open to a company to simply come into a country, pretend that the government has no policies in place with regards to the formalization of artisanal and small-scale miners, and insist that his strict legal rights be enforced regardless of their impact on the community. Likewise, under ICMS principles for responsible mining, principle number 9 on social performance, mining companies must implement inclusive approaches with local communities. They must also engage with stakeholders based on an analysis of the local context. And specifically in relation to ASMs, they must collaborate with government where appropriate to support improvements in environmental and social practices of local artisanal and small-scale mining. As we have already seen, that is consistent with the approach recommended by the ILO, the World Bank, the IFC, and other international organizations. That's what GCM has failed to do at Segovia and Marmato in his dealings with ASMs there, and we will come on to see shortly. GCM must have known that ASMs lived and worked at Segovia and Marmato before it invested there, and that the government's policies was to foster formalization, not their criminalization. Indeed, ASMs are truly a defining feature of both sides, and that was, of course, the case when GCM invested. Yet, GCM tried to gloss over this in his written submissions, and even this morning. Marmato and Segovia are both mining towns located in the northwest of Colombia communities, and Marmato and Segovia have carried mining activities for centuries. Actually, you have the coat of arms of Segovia, which reflects their mining origins. On the slide, this tribunal will find an excerpt from a report prepared by the OECD on due diligence in Colombia's gold supply chain, and specifically within Antioquia, the departamento or province where Segovia is located. The report describes the historical context in Antioquia and can be found at Exhibit R179. In short, this historical account confirms the long-standing mining tradition in Antioquia, dating back to pre-Columbian times. Later on, the minerals extracted through artisanal and small-scale mines in both towns were a source of income for Spanish colonizers. English and French companies then arrived in Segovia during the 19th century to conduct gold exploration operations. Frontino, initially a British mining company, you have heard about Frontino, the predecessor in Segovia, initiated operations at the beginning of the 20th century. The towns of Segovia and Remedios were born out of Frontino's operations in the region. The company carried out activities in the area for several decades and not only tolerated ASMs, but in fact entered into a contract with them and even provided training and technical support. Let's talk about Marmato. Marmato mining has also played a central role in the life of the community. And you see the coat of arms, again, shows the origins of Marmato. GCM's consultants' technical reports note that gold mining activities could be traced back to 2,000 years before the Spanish conquest in the region where Marmato is located. Importantly, the historic importance of mining in Marmato led the Colombian government in the mid-20th century to create a unique division of the area of Marmato for mining. And let me explain a little bit about this difference between Zona Alta and Zona Baja that you have heard described before this morning in the presentation by claimants. The town of Marmato is located within and literally on top of the titles of GCM in a mountain that is known as Cerro El Burro. This was divided into two areas, Zona Alta, or upper zone, and Zona Baja, or lower zone. This was done through legislation in the 1940s to guarantee an equitable and fair long-term distribution of the mining areas between ASMs and commercial mining companies. While Zona Baja was made available to the arrival of a single mining operator, Zona Alta was reserved to small-scale miners. While these laws changed in subsequent years, the equitable distribution of mining resources in the Cerro El Burro remained. This remained the status quo until GCM began purchasing a significant number of titles in the Zona Alta, as we will come on to see shortly. Now, another important piece of context that is conspicuously absent from GCM's written submissions is the history of the area and his role in the Colombian Civil War. And this comes back to the question by Madam President concerning this coexistence between small-scale miners and violent groups. As the tribunal will know, a civil war took place in Colombia over several decades. The conflict involved a myriad of armed actors with diverging interests. Guerrilla groups emerged during the second half of the 20th century, such as the FARC and the ELN. These groups engaged in attacks on civil society and financed their activities through drug trafficking. And in reaction against guerrillas, paramilitary groups were created in the 1980s and 1990s as private security forces. However, these groups also conducted violent attacks against civil society and were also involved in the drug trade. The Colombian armed conflict also involved drug trafficking cartels. It was a terrible war. All of these illegal groups were deeply harmful to Colombia, and thousands of Colombians have been kidnapped or killed, both in rural and urban areas, and millions forcefully displaced. At the time of GCM's investment in Colombia, illegal armed groups operated in Colombia mainly in rural areas of the country. In recent years, negotiations between the Colombian government and paramilitary and guerrilla groups led to their disarmament. The most recent development took place in 2016 with the agreement with the FARC. This agreement led to the disarmament of this organization and the development of national, social, and economic policies to develop the areas most affected by the armed conflict. For example, as a result of his historically difficult social and public order conditions, Segovia has been classified as a special zone for development and as a result is eligible for priority social investments. However, paramilitary and guerrilla groups are still present in some areas of the country and have filled the gap left by the FARC. These groups are joined by bandas criminales, known as BACRIMs, recent illegal groups created by paramilitary and guerrilla dissidents. Segovia and Marmato were among the regions most affected by the violence of the civil war. With regards to the situation of the armed conflict in Segovia, the tribunal will hear evidence from Mr. Fernando Gomez, Secretary of Mines of Antioquia. As he will explain, and as a number of documents on the record set out, Segovia has historically been the theater of violence as part of Colombia's internal armed conflict. Guerrilla, paramilitary, and criminal groups have fought to control the area and resources. Segovia is also known for the infamous Segovia massacre of 1988, led by a paramilitary group. The attack on civil population left more than 40 dead and more than 50 injured. The Machuca massacre in 1998 took place when the ELN guerrilla damaged a pipeline, leading to an explosion in Machuca, a neighboring community close to Segovia. The situation in recent years has remained unstable, and new attacks on civil society have taken place both in Segovia and Marmato. Now, GCM, like everyone in Colombia, must have known about this context when it invested. As we have seen, criminal groups linked to the Colombia Civil War and the drugs trade have long existed in these areas. And it is not disputed that GCM knew full well that ASMs lived and worked at Segovia and Marmato when it invested. In fact, in June 2010, 2 months before its investment in Segovia, GCM commissioned a technical report on the areas of the titles held by Frontino, surveying the ASMS and their activities. This can be found at Exhibit R130. The report confirms the extensive presence of hundreds of small-scale mines in the areas of RPP 140, as you can see on the map on this slide taken from the technical report. The small-scale mines are dots on the map, and the map records the Cogote mine and other mines run by associations of small-scale miners. GCM was also aware that the small-scale miners were present in Marmato before investing in the area. In October 2009, Medoro Resources and Colombia Goldfields retained Scott Wilson Consulting to prepare a series of technical reports on Marmato in the context of Medoro's acquisition of these assets. GCM then invested by merging with Medoro. The relevant report can be found at Exhibit C260. The report identified 250 independent mines in Zona Alta, only 95 of which held titles. The report said that working conditions were substandard by general norms, which, although inherent in artisan mining areas, had a particular impact on the community and exacerbated their conditions given that the Marmato town sits on top of the mineral deposit. Even GCM's witness, Mr. Gaviria, concedes that ASMs operated in Marmatos, H&D, and Zona Alta at the time GCM made his investment in this area. After we pointed out that ASMs at Segovia and Marmato had been there from the start, GCM spent much of its reply trying to suggest that the ASMs in Marmato and Segovia were invaders from other parts of the country. We heard that this morning. And that they began arriving long after GCM had made his investment. However, the record shows that they are not. For example, in 2012, Colombia's Ombudsman Office issued a report on the risk of human rights violation in Antioquia. The study, at Exhibit LG24, analyzed the risk relating to mining activities in Antioquia. It found that mining activities in Segovia are predominantly carried out by traditional miners that inherited their mining techniques from previous generations and that they derive their daily sustenance from such activities. Another report commissioned by the Ministry of Mines for the study of mining production units in Segovia in 2018-2019, Exhibit R244, confirms that 97% of the workers operating at Segovia are locals. The evidence relied upon by GCM to claim that ASMs operating in Marmato allegedly arrived from other regions in Colombia confirms actually the opposite. GCM refers to a study of mining production units in Marmato prepared by Office of the Mayor of Marmato in 2017, Exhibit C367. But as the tribunal can see on the extract set out on this slide, the report actually found that the artisanal mining activities in Marmato were mainly conducted by Marmato's own inhabitants. The report also found that most of the workers operating in Marmato are originally from Marmato or from neighboring municipalities such as Supía and Rio Sucio. The announcement of the development of a potential large-scale project in Marmato attracted, of course, some miners from other regions of Colombia to Marmato. However, far from being particular to Marmato, experts confirmed that new mining projects commonly lead to influx of informal miners. For instance, the 2008 Working Together report that we already referred before from the World Bank and the IFC notes that, and I quote, when new mineral areas are discovered and the mineral type lends itself to small-scale excavations, transport, and sale, opportunistic immigration or an influx of ASM miners is seen. In any case, the arrival of miners in Marmato from elsewhere in Colombia was marginal. GCM certainly hasn't adduced any evidence to prove otherwise. So far, for the context, you have seen the importance of ASMS, the social license to operate, the situation present in Segovia and Marmato at the time of GCM invested, both at the level of GCMs and at the level of violent groups because of the circumstances, particular circumstances surrounding that area in Colombia for the most part of the 20th century. See now how GCM comes into the picture and in the investment. Segovia, as you know, was an area that belonged to Frontino. Frontino had been there for years. Frontino had negotiated with la Asociación El Cogote, etc. Frontino basically went bankrupt, and the assets of Frontino were put up for liquidation and were offered internationally. This is the story of this situation. The liquidator, and we will hear evidence from the liquidator, Mr. Alvarado, liquidator of Frontino, decided to commissionate investment banks to offer those assets. The investment banks opened a competitive bidding process in 2008-2009, inviting more than 200 multinational mining companies. 200 multinational mining companies invited to bid for the assets of Frontino. Among the companies invited to make an offer, only 12 companies manifested an interest in Frontino assets. Out of those 12, only 8 companies accessed the data room that was created for this operation. Out of those 8 companies that accessed the data room, only 5 companies organized technical visits to the Segovia and Marmato sites, and Mr. Alvarado himself was part of those visits. So 200 companies invited, 12 manifest some kind of interest, 8 actually get into the data room, 5 go to the site. How many made an offer? 0. None of the companies extended an offer by the deadline of 30 June 2009 in light of the risk identified in Segovia. And ultimately, in November 2009, GCM, through a company called Sandor, made an offer to buy the title for around $200 million. The amount was intended to cover Frontino's pension liabilities, but no more. Now, the sale process was opposed by the local community and was challenged before the Congress, the Colombian Congress. In August 2010, Mr. Alvarado and other government officials, including the Minister of Mines and the Superintendent of Corporations, were summoned to a congressional hearing to discuss the circumstances surrounding the liquidation and sale of Frontino's access to GCM? Why so little attention was such a little price? Questions were raised as to why effectively so little interest was expressed by international investors and why GCM was paying so little. We have set out on the slide an excerpt of the testimony of Mr. Alvarado and the Superintendent of Corporations before the Congress, which can be found in Exhibit R205. The tribunal is invited to read the entirety of this document at its leisure. As Mr. Alvarado and the Superintendent of Companies explained, GCM knew that it had bought a problem. They explained that the sale process was very difficult because, and I quote, there is an issue of reputational risk. The truth is that exploiting Segovia today is complicated for a mining company that is in London or Toronto. It is not the same to exploit a gold mine in the province of Saskatchewan, says Saskatchewan, but they were referring to Saskatchewan, in Canada, as in Segovia. This confirms that GCM clearly knew it was taking on a very risky project in an historically volatile area. But GCM agreed to assume those risks in exchange for potentially high rewards, which is reaping in spades. I will now transfer the PowerPoint to my colleague Diego Romero, who will continue with the presentation.
Good afternoon, Madam President, members of the Tribunal. I will now address GCM's conflict with the social communities of Segovia and Marmato, as well as GCM's allegations regarding Judgment SU 133. So now, what exactly was GCM's plan when it invested at Segovia and Marmato, and what happened? Tellingly, GCM has chosen not to submit any documents or testimony on this subject. However, as we will come to see, at least part of the truth seeps through the cracks of some of GCM's documents. The record shows that GCM factored in the presence of ASMs in its plans for both Segovia and Marmato as part of its business plan, but failed to gain the acceptance of a significant number of them. Let's start with Segovia. So within the first year of operations, GCM established a model by which over half of its population came from ASMs. We can see that from GCM's management discussion and analysis document from the fourth quarter of 2011, published in March 2012, that is Exhibit C37. This confirms that GCM entered into 22 contracts with cooperatives of artisanal miners at the Segovia operations. So from the very outset, those contracts accounted for between 50 to 60% of GCM's total gold production from its Segovia operations. In other words, in 2011, over half of GCM's production was the result of the work of ASMs. GCM's document, published to the stock market, also touted its success in locking in these contracts, which were very profitable to it. Indeed, it said that the company had essentially locked in an operating margin of approximately 30 to 35%, and that the ore tends to be a much higher grade than the ore mined by the company at its operated mines, and is as such an important source of operating cash flow. So far from telling its investors in Canada that it had a massive problem with criminal invaders, GCM actually confirmed that ASMs were an integral part of its business model at Segovia and an important source of cash flow. The tribunal will also note that at the same time, GCM was saying that it intended to continue seeking to enter into contracts with ASMs, GCM sacked nearly half of its own workforce. As part of its purchase of the Segovia assets, GCM had committed to maintain a workforce of around 1,400 workers during its first year of operations. As soon as that contractual requirement was up, GCM fired 42% of its workers and created its small mining supply chain program, through which it sought to enter into more flexible contracts with ASMs. That, members of the tribunal, was GCM's model. So now, at the same time it was offering operation contracts to ASMs, GCM sought eviction orders in order to use them as negotiating leverage. That is not disputed. Those are GCM's own words from its statement of reply in relation to its negotiations with El Cogote Association, one of the largest and oldest ASMs in Segovia. As we have seen, seeking to use force to displace ASMs is not consistent with international good practice, and it generates ill will and conflict with ASMs. Unsurprisingly, threatening ASMs with eviction did not go down well, particularly with groups of ASMs such as El Cogote, who had a strong sense of belonging and ownership of their mines, as well as wide community support, having been there for over 40 years. The tribunal will hear from Ms. Elizalde and Ms. Gonzalez, who traced through the history of this in their report and carried out interviews with members of the local communities. They explained that GCM's policy of filing amparos as a pressure mechanism further increased the confrontation and conflict with the communities, and was a highly misguided approach. One of their interviewees reported feeling constantly criminalized and harassed. It's unsurprising, in these circumstances, that GCM was unable to secure the support of part of the community at Segovia. GCM's approach at Marmato also caused a huge conflict with the local communities. As the tribunal knows, GCM's intention was to carry out an open-pit mining project. Open-pit mining is high-volume, low-cost mining, so it can be hugely profitable, but it's environmentally and socially destructive, and therefore rarely a viable option. Here, the open-pit project, which had been started by Medoro, with which GCM merged, would have required GCM to displace the entire population of the town of Marmato, 55,000 people, and shut down their existing mines. While GCM says it entered into agreements to pay some of the existing ASMs to leave, its approach to its negotiations was as aggressive as it was at Segovia. The tribunal may have seen that we filed as one of the exhibits Marmato, an award-winning documentary that covered the plight of the local miners at Marmato faced with eviction between 2008 and 2013. We wanted to play a couple of short excerpts for the tribunal this afternoon, which in our submission are very revealing. In this excerpt of the documentary, Medoro's drilling manager visits Marmato and has a discussion with the local miners about what is going to happen to them.
Here, and it's going to happen within the next couple of years. And these people's homes are they're going to get offered so much money for their home, what they think is fair, not what you people think is fair, what they think is fair. And if you don't move out of their home, they're going to bring in the army, the military, they're going to put you on buses and they're going to take you out of here.
O sea que nos van a desalojar.
Es legal.
Is that legal? Do you think?
No, but they're going to do it.
Él dice, no, eso no es legal, pero es lo que van a hacer. O sea, eso es lo que él ha visto.
Sí,
en las partes
en
donde
otros
él ha
países.
estado. Que eso es lo que va a pasar. Y él dice, no, eso no es legal, pero igual lo van a hacer.
They will make it legal.
No tenemos futuro.
We have no future or anything.
And here's another discussion between Luca Altamura, GCM's former vice president.
Mr. Romero, before you
Sorry.
go on to the next clip, do you know who the gentleman is in the first clip who is informing the miners that this is what he believes to be GSM's
Yes,
plan?
that's Mr. Lawrence Sparks, drilling manager at Medoro. And the other,
I'm sorry, drilling manager
at Medoro. So the company GCM merged with.
Here, and it's going to happen in the next couple of years. And these people's
Sorry. And there's a second video, which is a discussion between Luca Altamura, which is GCM's former vice president of corporate affairs, and ASM's about what is about to happen to the town.
Entonces, por esta razón, sigue, esta es la mejor oportunidad que este pueblo va a tener en los 500 años de historia que tiene. Entonces, si yo pero creo un precedentes aquí...
¿De cuál pueblo hablamos? ¿De cuál pueblo? No existe pueblo. En el proyecto no existe pueblo.
como no existe.
No existe pueblo. ¿Dónde va a quedar el pueblo?
No entramos en esto, porque esta es la más...
Hábleme con la verdad.
In our submission, these videos only begin to show what really went on at Marmato, and why it's not surprising that GCM hasn't been able to gain its social license to operate there.
Here, and it's going to...
Now, it's not disputed that in light of the social opposition and tumbling gold prices, GCM decided to abandon its open pit project at Marmato. The tribunal can find an interview that GCM's CFO Mike Davis gave to Northern Miner, a trade publication, at exhibit GD18. In that interview, Mr. Davis admits that the open pit project was no longer economical in light of the drop in gold prices, and that the project had faced social issues because of the need to relocate the town. This explains that GCM put its Marmato project on hold until 2017, when it decided to consider whether an underground project that might face less social opposition could be feasible. GCM engaged SRK Consulting to prepare a technical report, which is at Exhibit C28. In that report, SRK recommended that GCM incorporate production from ancestral and tradition miners working within GCM's titles, following SRK's recommended contract mining model. SRK noted that this could potentially reduce potential social issues, which were opposed to in the previous plan for open pit mining. And SRK noted that it understood that GCM intended to implement that model. And so, here again, GCM's business model involved seeking to make a profit from the ASMs at Marmato. Yet at Marmato, too, GCM sought a multitude of amparos to evict ASMs. Unsurprisingly, like at Segovia, this continued to cause conflict with the ASMs, some of whom initiated a tutela proceeding that led to the judgment SU-133 that we will come to see shortly. So this morning, the tribunal asked whether there was any precedent or evidence regarding the lack of enforcement of amparos, whether there was any contemporary evidence on the record. And this is precisely one of them. GCM knew, or should have at least known from the very outset, that it could not count on the mayor, the democratically elected local authority, and the one entrusted by the 2001 Mining Code to enforce these amparos, because that's not what mayors do as a matter of policy and practice in most cases. It's very revealing that GCM has put forward a single witness to testify about what GCM knew about the effectiveness of amparos when it decided to invest, or what GCM was actually expecting. But the record is replete with documents confirming that Frontino, GCM's predecessor at Segovia, filed amparos against various groups of ASMs and that they were not enforced. So we've set a couple of excerpts on the slides. As an example, we'll find Exhibit R62, which is correspondence concerning Frontino's inability to enforce an amparo in 2008 against El Chocho, Ruby 1, Ruby 2, La Coramina, El Platanal, and La Vereda Po mines. I'm sure some of these the names of some of these mines are already familiar to you. Another example, Exhibit MR12, is an August 2005 report from technical consultants to Frontino, recording that Frontino had not been able to enforce an amparo against the San Nicolas mine. Again, I'm sure this name is already familiar to you. And Mr. Alvarado, Frontino's liquidator, will testify during the due diligence process, Sandor, GCM's predecessor, was certainly aware of the fact that many amparos filed by Frontino could not be enforced. So it is remarkable that GCM now claims that it expected amparos to be enforced when GCM knew that Colombia's authorities had previously not done it. It is also very revealing that outside of this arbitration, one of GCM's experts, Mr. Dr. Leonardo Guisa, recognized in a 2010 report by the Colombian Office of the Ombudsman that amparos have significant enforcement limitations and are consequently often not enforced. That is at Exhibit LG1. The report notes that the Ombudsman had confirmed that local authorities do not have the capacity to enforce amparos, and that they do not generally do so because of the risk of disruption to the public order. Mr. Guisa also noted that budgetary constraints made it difficult for mayors to enforce amparos. And notably, he also noted that the closure of informal mines may constitute a social problem in light of the fact that these activities are the only source of income for many families. He also acknowledged that informal mining can be carried out by ancestral miners that would require alternatives of work and subsistence in case of eviction or closure of their activities. All of this was public knowledge when GCM invested, of course. GCM's expert observations are particularly relevant at Marmato and Segovia, two of Colombia's poorest municipalities. GCM has tried to paint the lack of enforcement of amparos by Colombia as a complete and systematic disregard of their duties under Colombian law. However, far from being a dereliction of their duties, the authorities have not enforced amparos for legitimate reasons, mainly relating to the need to maintain public order. Those reasons are recorded in various documents on file, and GCM has sincerely disputed that the concerns they express are well-founded. Take one example. The Office of the Mayor of Segovia tried to enforce amparos in August 2015, but was unable to do so. A certificate issued by the Secretary General of the Municipality of Segovia at Exhibit R64 confirms that it was not possible to conduct the required site visits because of the risk of public disturbances. Shortly thereafter, in November 2015, ASMs in Segovia organized a work stoppage, or paro, in response to the Procuraduría's order to the mayor of Marmato to enforce amparos granted by GCM. The paro led a massive number of Segovians to protest against the enforcement of these amparos. We set out a picture of the 2015 paro that can be found in a news article at Exhibit R87. As the tribunal can see, the 2015 paro drove crowds of Segovians to protest. But despite knowing that amparos would not be enforced and that threatening ASMs with eviction would not be conducive to good relationships with them, GCM persisted in filing a multitude of amparos. In this arbitration, GCM seeks damages for the impact of work stoppages resulting from instances of paros, which are blockades by local miners that GCM says brought its operations to a halt. But the record shows that GCM caused these paros one way or the other, and in any event overstates the impact of these paros on GCM's operations. In Segovia, GCM's purchase of Frontinos' assets in 2010 led to a strike in September of that year, as members of the community believed, and some still believe, that the sale was irregular and that Frontinos' assets belonged to the community. These protests, which lasted about 2 weeks, left 10 people injured and required the deployment of the ESMAD, or the riot police. These events are described in Mr. Alvarado's and Mr. Gomez's witness statements, as well as contemporary news report found at Exhibit R204. Later on, in 2013, the local miners protested for 15 days for the official recognition of their mining titles. This time, the miners in Marmato protested for the perceived criminalization of their activities and the return of the areas where they operated before GCM's arrival. In order to address the protest, the government negotiated with the informal miners and sent the anti-riot police in order to prevent the social protest from getting out of control. This is recorded in news articles at Exhibits R79, R213, and R411. I found this on the web. In February 2015, Marmato ASMs protested for 2 days against the closure of their mines by GSM. This is recorded in an article at Exhibit R 2017. Miners in Segovia also reacted to GCM's attempts to evict them. In November 2015, the local miners led a paro for 15 days in reaction to an order by the Procuraduría General to enforce the amparos granted to GMC. An article published at the time of the paros at Exhibit 886 noted that the enforcement of the amparos concerned 15 mines in Segovia, where more than 8,000 ASMs operated. As GCM's management and discussion analysis document records, the government addressed the security issues by sending officers and soldiers on site. The document can be found at Exhibit C41. And in September 2016, the ASMs protested for 11 days. Here again, GCM's management's discussion and analysis document records that Colombia's officials visited Segovia and negotiated with the local miners to bring the paro to an end. This document can be found at Exhibit R92. Between July and September 2017, the miners at Segovia protested for 42 days against GCM's position during the negotiations at the Mesa Minera de Soluciones, a formal roundtable to analyze and propose solutions to the issues surrounding the formalization of ASMs. GCM claims that the miners protested against the government's actions, when in fact the local community protested against GMC and its refusal to acknowledge their rights. The evidence for that can be found at Exhibits R235 and R236. The government certainly protected GSM in response. The mayor of Segovia declared a state of manifest urgency and implemented a night curfew by decree of July 31st, 2017, which is found at Exhibit R236. Colombia also sent police forces to prevent the degradation of the situation. In the aftermath of the 2017 paro, GCM even thanked the government for its support during the strikes in a letter of September 2017, which can be found at Exhibit R69, which we'll in fact see next. So in this arbitration, GCM and its witnesses contend that Colombia's authorities did nothing to protect GCM's investments. However, this is directly contradicted by evidence on the record, which shows that Mr. Paredes and Mr. Noguera both wrote to the Colombian authorities following the end of the 2016 and 2017 paros in Segovia to thank them for their efforts in overcoming these events. Clearly, GCM would have never expressed such level of gratitude had it genuinely believed that Colombia's authorities did nothing to protect their investments. Now, GCM also says that public order does not explain why many of the amparos it has filed are unresolved or unprocessed, rather than just not enforced. The reason a number of the amparo applications have not been resolved is really the same. Colombian law requires the authorities to conduct a site verification visit in order to decide on an amparo administrativo application. However, the social and public order conditions in Segovia and Marmato have routinely prevented the authorities from conducting many of such visits. In fact, community opposition has also often prevented the notification of the decision fixing the date of site verification visits. Mr. Gomez and Mr. Chavez will testify to this in the next few days, and they will explain that absent a verification visit, there can be no decision on an amparo, let alone an eviction. We've also set out on the screen examples of documents from the A&M and the Mayor of Segovia recording the difficulties faced by the authorities in attempting to complete the steps required to decide many of the amparos. These are Exhibits R64 and R65. Additionally, GCM says that there is no legal basis for the authorities to fail to process or enforce amparos. That is not the case. Colombian courts have rightly recognized that amparos should not be enforced in all circumstances as a matter of law. The tribunal will have seen the decision of the Administrative Court of Appeals of Antioquia, the highest court of the Antioquia departamento or province. This decision was issued in the context of an enforcement claim or acción de cumplimiento filed by GCM before the Antioquia Administrative Courts, which challenged the Mayor of Segovia's failure to enforce the amparo granted by the A&M in 2015 against El Cogote and other mines. The first instance court rejected GCM's application, finding that the social and public order context of Segovia justified the non-enforcement of the amparo. The court also considered that the non-enforcement was justified, since the Mayor of Segovia had not simply ignored or disregarded the order. Rather, the court noted that negotiations sponsored by the Mayor of Segovia were ongoing and sought a peaceful agreement between GCM and the ASMs. The reason of the Court of First Instance can be found at pages 4 to 6 in Exhibit C156. GCM filed an appeal against the decision of the Court of First Instance. However, the Administrative Court of Appeals upheld that decision. The Court of Appeals ruled that the Mayor of Segovia had used the available means to tackle the economic and social issues particular to the activities of El Cogote. Its decision can be found at pages 15 to 27 at Exhibit C156. In light of the social, economic, and cultural context in Segovia, the court considered that the mayor complied with its functions by promoting the creation of the Mesa Minera and encouraging GCM and the local miners to reach agreements. The court went on to rule that the participation of the mayor at the negotiation board was a manifestation of the fulfillment of his obligations. The Court of Appeals also added that the mayor's obligations stemming from the amparo granted to GCM did not, under the circumstances, compel the mayor to evict or use forceful means against informal miners operating in the area. It is telling in our submission that GCM never challenged this decision, for example, through a tutela motion to a superior court, or sought the enforcement of the other amparos through the courts. Similarly, GCM's legal experts are conspicuously silent on this matter. GCM knows that it has no leg to stand on as a matter of Colombian law. In this arbitration, GCM claims that Colombia should have conducted a police and military operation similar to Operación Creta, the police intervention that took place in Buritica. But the situation that justified this intervention is not even remotely similar to the circumstances present in Segovia and Marmato. Three main differences between the social and economic context of Marmato and Buritica on one hand, and Marmato and Segovia on the other, explain why a police operation to enforce GCM's amparos and evict informal miners is not justified, and in any event would necessarily fail. The first difference is that Buritica's crisis was triggered by a sudden and massive arrival of migrant gold seekers. Prior to the 2010s, Buritica mainly depended on the production of livestock and other agricultural products such as coffee. As shown in the fact sheet of the Municipality of Buritica prepared by the National Planning Department at Exhibit R182. After the arrival of Continental Gold and the announcement of its large-scale mining project, starting in 2012, the town became flooded with miners and other individuals from the different regions of Colombia, and in a matter of months, the population almost doubled. Contemporary evidence, such as the news article produced as Exhibit R92, accounted for the arrival of close to 5,000 individuals to Buritica. Please bear in mind that Buritica was a small town with around 6,000 people only. As mentioned by a local news segment on Buritica, the sudden increase in population resulted in troubles to the public order. We will just play a short excerpt of that.
En 2012, Buritica inició un proceso de cambio muy acelerado relacionado con una actividad informal minera que se empezó a desarrollar en algunas zonas del municipio. Entre 5 y 7 mil personas, en su mayoría provenientes de otras zonas del departamento e incluso del país, se asentaron en el sector de San Román, vereda Los Asientos, para trabajar en la minería en condiciones deplorables.
El hacinamiento fue tremendo y eso trajo pues unas consecuencias desastrosas, desafortunadamente. El aumento de la basura, el aumento de inseguridad, el aumento de sustancias, en el consumo de sustancias psicoactivas, el licor, sitios para los trabajos sexuales.
The sudden avalanche of individuals seeking to mine in the area led to severe disturbances to the public order. Housing options became scarce, the increased population put pressure on the public utilities, and crime levels worsened. The intensive work by the newly arrived miners posed a threat of landslides. In addition, unsafe mining conditions led to serious accidents, one alone claiming the lives of 4 miners and severely injuring more than 90. The serious deterioration of the situation led to the police operation conducted in 2016. The same news segment covered the evacuation of Buritica, and we will play that now.
El uso del mercurio nos está afectando bastante.
Buritica no estaba preparado pues, para recibir toda esta gente que en este momento está dentro de nuestro municipio.
Ya hay una vereda donde el agua para el consumo humano ya no existe.
Aunque no dejó víctimas el deslizamiento de unos muros artesanales de contención presentado el viernes 18 de octubre de 2013, fue el detonante para que saliera a la luz pública la situación que se vivía en Buritica, municipio al que llegaron miles de personas en busca de trabajo, muchas de ellas en graves condiciones de riesgo. El 19 de noviembre de ese año se declaró la calamidad pública y se obligó a cerca de 4.000 mineros a salir de la localidad. La evacuación fue ordenada por la gobernación de Antioquia debido al inminente riesgo de deslizamiento en una montaña con más de 300 perforaciones para extraer oro y sobrecarga por alta ocupación.
Pero a mí me tienen que matar porque yo no me voy a sacar de ahí.
Ello generó un choque entre la fuerza pública y los mineros que se negaban a abandonar la municipalidad.
The second difference is that the population of Buritica supported a police and military intervention. While the population supported this intervention, a similar military operation would be strongly resisted by the local population. If a massive operation were to take place, the population of Marmato and Segovia would literally have nowhere to go. Further, a military operation of this kind would not guarantee that miners would not return to Marmato and Segovia to resume their mining activities. In fact, the experience of Buritica proves the opposite, as shown in a recent news report at Exhibit R253. The population of Segovia, which is almost fully directly or indirectly involved in mining activities, is almost 10 times the size of Buritica at the time of Operación Creta. And as confirmed by Mr. Chavez, in order to replicate Operación Creta in Segovia or Marmato, the armed forces would require almost 2% of Colombia's total police and military armed forces. And the third difference is that there is a direct in Buritica there was a direct link between the migrant gold seekers and the illegal armed groups. In fact, most of the illegal miners that flooded Buritica were supported or acted in coordination with the Clan Usuga, which is now known as Clan de Golfo. You can see that at Exhibit R91, pages 2 to 4. It is precisely in response to the criminal activities in Buritica that the Colombian authorities ordered the military intervention known as Operación Creta. As also explained by our witness, Mr. Chavez, who participated in the planning and execution of this operation, the intervention aimedly aimed at tackling the Clan Usuga's criminal activities and cutting an important source of funding for this criminal armed group. So GCM also says that Colombia has failed to deal with organized crime at Segovia and Marmato, but that is not true. This week, the tribunal will hear from Mr. Chavez, who not only participated in the organization of Creta, but has also been in charge of leading, or at least has been involved in Colombia's efforts to combat illegal mining from a law enforcement perspective. Mr. Chavez will explain that contrary to GCM's claims, the Colombian authorities do intervene against illegal mining when it's linked to organized crime. From 2009 to 2021, the police successfully dismantled a criminal organization linked with illegal mining activities in La Rubiela mine in Segovia. This criminal organization was involved in this illegal sale of explosives, illegal exploitation of resources, and environmental contamination. The report of the operation, found at Exhibit C-505, shows that the individuals involved in the criminal operations were arrested. In order to combat the activities of this group, the police also seized their assets and initiated property extinction proceedings. On the left side, you can see the arrest of one of these of the members of this organization, and the lower part of the slide shows the operations of seizure of their assets. Now I will move on to GCM's contentions regarding Judgment SU-133. But before I do that, I would like to provide some context. As we just saw before, GCM has never conducted any mining operations in the Zona Alta, nor does it have the requisite technical and environmental authorizations under Colombian law to do so. Since it acquired its mining titles in this area, there have been numerous informal miners operating there, but GCM has not extracted not even an ounce of gold. Yes.
Mr. Romero, I don't want to interrupt you in the middle of a slide, but we're at about the scheduled time for a break, so if you're about to be going to a new topic.
It's a good time to stop, yes.
Okay, and you may want to consider during the break, as it appears to me that you're about 1/3 of the way through your slide deck, but 1/2 of the way through your time, so you may want to think about that.
Of course, thank you.
All
so
right.
we'll stop, I guess.
Okay, fair enough. All right, so we will take a 20-minute break now, and we'll return at, where are we now? Just about 5 minutes to the hour. Oh, thank you. Great minds. Thank you. We resume now. Mr. Romero, whenever you're ready.
Thank you, Madam President. So I was discussing some of the background. Some of the background of Judgment SU 133 as far as the mining project, Gran Colombia's alleged mining project is concerned. So at the time, there was really no project at all. There was no environmental license. There was no technical report authorizing exploitation activities. And the only thing that existed, frankly, was the 2017 technical report, which recommended, as we explained before, that production from any eventual small underground mining project come from ancestral and traditional miners working within GCM's titles. So it was clear at the time that these ASMs were there and they would need to be factored in for the development of any mining project there. So aware of this, Gran Colombia instead chose the easy route. It opportunistically claims that Judgment SU 133, issued on the same year as this technical report, expropriated GCM's titles in the Zona Alta and dashed all hopes that the Marmato project could ever be developed. But as we will see next, Judgment SU 133 has not even remotely done such thing. Judgment SU 133 is the result of a tutela application, which under Colombian law is an application for the protection of fundamental constitutional rights by ASMs at the Villonza mine, and they sought to suspend and overturn an eviction order issued by the A&M. The applicants, the mining authority, the applicants contended that the approval of the assignment of contract CHG 801 to MAO, one of the claimant's subsidiaries, violated the right to community consultations due to the risk that the concentration of such rights in the hands of this company, which intended to develop an open-pit large-scale mining project in the area, could permanently alter the social and economic fabric of Marmato. GCM claimed that prior consultation was not necessary for the assignment of the mining rights, since first, there was no evidence of ethnic communities living or operating in the area of the contract, and two, prior community consultations are only required for the application of an environmental license. The case reached the Constitutional Court, where it was selected for revisión or review, which is similar to certiorari here in the States, due to the novel issues it presented regarding constitutional rights to public participation and community consultations. During these proceedings, the court invited academic institutions to file amicus briefs on the social and cultural context of Marmato and its historic mining traditions. It also ordered or allowed the joinder of the Cartama indigenous community and a local Afro-descendant organization. The court also conducted a site visit to the area of the project. On 27 February 2017, the court issued Judgment SU 133, which annulled the eviction order and ordered the authorities to conduct a consultation process with the informal miners of Marmato, as well as the Cartama indigenous population and the local Afro-descendant communities. In Judgment SU 133, which stands for Sentencia de Unificación, or unifying judgment, which is a judgment that basically unifies the court's jurisprudence on a particular topic and is issued by the entirety of the court decided two issues. First, whether the communities of local miners and the ethnic communities living in and around the Villonza mine at Marmato needed to be consulted before the A&M approved the transfer of contract CHG 801 to GCM.
Could I jump in and ask here that, as I understand it, there were two different groups whose rights were addressed by the Constitutional Court. There's what you've just called traditional miners, and the heading of your slide talks about participation in a decision-making process. And then there's the indigenous and Afro-descendant communities, and there the word is consultation. Is there a difference between participation and consultation? Is the court imposing two different processes or one process that benefits both groups?
Yeah, thank you for your question. So the legal basis for both is different, but the outcome is really the same. It's a consultation process. The requirement to conduct ethnic consultations comes from essentially ILO Convention 169, while the consultation with the local community, it's more of a right to public participation, which is a fundamental constitutional right. But both really have largely the same effect.
So in terms of implementation, what the government is supposed to do in compliance with this decision is one process that would involve both the local community and representatives of indigenous groups, or two separate?
No, it's the same process, but they will all be involved, and we'll see one of the new exhibits on the record, which has moved forward a bit. This process will show that it's a single process, but involving all these communities, these participants. So, with regards to the first issue, the court found that the specific effect of the assignment of mining rights on the local communities requires a case-by-case analysis. The real question is whether communities might be impacted by the transfer itself. The court reviewed the particular circumstances of Marmato, and as I mentioned before, it even conducted a site visit, or commissioned the local judge to conduct a site visit, and found that the assignment of contract CHG 801 clearly impacted the local mining community. In particular, the court found that a transfer of titles from small miners to an industrial miner massively changed the democratic balance that had been established with the attribution of the Zona Alta to small-scale miners in the 1940s. And as evidence of that, the court found that, in fact, these mines had been closed, and that led to a very serious social and economic crisis in the area. And so the court concluded that the local mining communities had a constitutional right to participate in the decision-making process of the transfer of mining title rights covered by Title CHG 801. With respect to the second issue, the court considered whether the ethnic communities in Marmato and its surroundings had a right to prior consultation prior to the assignment of their mining rights, of the mining rights. In its submissions before the court and this arbitration, GCM says that there were no mining ethnic communities in the area of its titles. According to GCM, the Colombian authorities did not identify registered mining ethnic minorities in the area of the titles in their certificates. However, applying Articles 40 and 330 of the Constitution and Article 6 of ILO Convention 169, the court held that the real question was not whether there were any of these communities within the area of the titles, but rather whether they were directly impacted by the measures at issue. The court found that the indigenous and Afro-descendant communities of Marmato could be directly impacted by the assignment of mining rights, even if they were not directly located in the area. The court also applied long-standing jurisprudence by finding that the presence of ethnic minorities is not necessarily reflected in the official registration based on governmental criteria. On this basis, the court dismissed GCM's argument that sought to prevent the recognition of the Cartama and Afro-descendant communities in Marmato as you know, entitled to a community consultation. The court arrived at this conclusion after having taken into consideration the views of many stakeholders involved in the transfer of mining titles in the area. Specifically, the court considered the views of the national government authorities and also the views of other interested parties, such as GCM itself, the Cartama indigenous population, the Asohomar community, and a local Afro-descendant community, and other traditional mining or artisanal mining associations, and also scholars. All of this is recorded in the court's decision itself at Exhibit R154. The procedural history of Judgment SU-133 specifically lists all of the intervening parties. These were open proceedings, and GCM filed extensive submissions on them. GCM now claims that Judgment SU-133 went against the law, against Colombian law. According to GCM and its expert, Professor Martinez, Judgment SU-133 departed from established jurisprudence. Colombia submits that that is not the case. The court's decision actually follows its own established jurisprudence. We have addressed this in our written submissions and have set out some references to those precedents cited in the judgment up on the slide. As an example, one of the precedents on which the court relied on was Judgment T-10-4 245A of 2010. In that case, the court also suspended the enforcement of an amparo pending the completion of a consultation process with ethnic minorities required in the context of the issuance of mining rights to a company in the region of Cauca. This precedent can be found at Exhibit R148. Excuse me. GCM now claims that the Constitutional Court went against the law. I'm sorry. In this arbitration, GCM has essentially made the same arguments that it deployed in the domestic proceedings, because also judgment SU 133 was actually challenged by the same court, by Gran Colombia and others, and the court issued a decision rejecting the application for annulment. Those arguments were the arguments made at that instance are also being made by Gran Colombia here now. And those arguments were appropriately considered and dismissed by the court. As you are aware, Gran Colombia or GCM claims that the judgment SU 133 was based on two faulty premises. First, it claims that the court was wrong to recognize the presence of indigenous communities in the area of Title CHG 801. To this effect, GCM relies on the letter sent by the Ministry of Interior confirming the absence of registered indigenous or Afro-descendant communities in the area of the title. But GCM's argument is premised on an incorrect reading of judgment SU 133. In this judgment, the court did not find that the Cartama community and the members of the local Afro-descendant communities were present within the precise area of the title. The court found that the transfer of the mining rights directly impacted these local communities in the vicinity, even if there were not people living directly within the area of the title. Second, GCM claimed that there was no need for prior consultation before the assignment of a title, since one would only need to be conducted in the context of an environmental license application. The court rejected this argument and considered that prior consultation was warranted in the context of the assignment of mining rights, and that holding off the consultation until an environmental license application was necessary would deprive them of the right to be consulted meaningfully and in accordance with ILO Convention 169. The court noted in particular that the fact that the disruptive effect that the arrival of GCM and its predecessors to Marmato had on the community warranted this precise consultation. This is recorded in the court's reasoning, and it is not open for GCM to relitigate this case before its case before the tribunal. GCM also claims that judgment SU 133 decided that the Marmato miners were traditional miners under Colombian law, and that it accorded mining rights to them. But judgment SU 133 has not even remotely said that. The court simply found, on the basis of the evidence on the record, which included a site visit conducted in April 2015, which can be found at Exhibit R22, that many of these miners or their families had begun working in Marmato periodically or interruptedly for decades. Contrary to GCM's assertions, this did not grant these miners any mining rights over the Zona Alta. From a Colombian constitutional law perspective, this fact simply made them a particular community, entitled to participate in any decision that would directly impact them. It is also not true that judgment SU 133 ordered the relevant authorities to find a way to accord mining rights to these people. Judgment SU 133 simply stated that the authorities had to adopt measures to ensure that the approval of the assignment did not affect the historical right of these communities to undertake mining activities in the area to ensure their subsistence. Clearly, this is not the same as granting a mining title to these communities. These miners can be employed by GCM or granted operation contracts or be formalized in any other way, much like it already occurs in Segovia. Through this order, the court simply wanted the relevant authorities to make their best efforts to protect the livelihoods of these people. They simply wanted to avoid what had already happened in 2008 when Mao, GCM subsidiary, closed all the mines and caused an unprecedented social crisis. And finally, I will address, GCM claims that Colombia's authorities have failed to implement the Constitutional Court's orders in judgment SU 133. But the record shows that Colombia's law authorities are complying and carried out the required consultations. First, the court ordered the Office of the Governor of Caldas to create a website dedicated to publishing information relating to the consultation process ordered by the court. This order has been complied with, as it can be shown on the record, Exhibit R195. The court also ordered the A&M to prepare reports on issues relating to mining in Zona Alta and the impact of the assignment of the rights covered by Title CHG 801. The A&M prepared and published these reports in compliance with Judgment SU 133, a few months after the decision was rendered. This can be found at Exhibit R241. Third, the court ordered the Office of the Mayor of Marmato to prepare a report on the impact on the authorization of assignment of mining rights covered by Title CHG 801. However, while the mayor prepared this report in 2017, the Procuraduría considered that the report was deficient and commissioned it to and ordered it to prepare a new report. The mayor then recused itself because, as a democratically elected member of the community, it thought it was appropriate to preserve the integrity of the process to recuse himself. The Procuraduría then appointed an official from the Office of the Governor of Caldas, but that was annulled due to due process grounds, and as a result, and also the problems related to the COVID pandemic have delayed the presentation of this report. As we have explained in our pleadings, it is common for complex prior consultations in the mining sector to take many years in order to identify relevant stakeholders and to conduct the necessary process. GCM cites, yes.
Well, just to be clear, as I understand it, the last act that occurred, at least as far as the record shows, was that the ad hoc mayor who was appointed to replace the one who had recused himself essentially said, I don't have the budget or the resources to do more, and that was, what, 2019, 3 years ago. So am I wrong? Has anything occurred since then?
As a matter of fact, it has. I will address that shortly.
Okay.
So, or actually right now. So, and the fourth reason why the process, the Colombia's authorities have made their best efforts in implementing this judgment is that as late as August 18 of this year, the A&M ordered a public hearing to publicize and explain to the local communities the contents of these reports. This public hearing will take place on 21 October 2022, so next month. And once this consultation process is completed, GCM is expected to be able to resume its activities in the Zona Alta. And it's this document.
Sorry, if you could just explain that. You said there'll be a public hearing to explain to the local communities the contents of the reports. I thought that the reports themselves had not yet been fully completed because the ad hoc mayor said he didn't have the resources to do so. So what reports are being publicized?
So the A&M took the view that the reports that have already been prepared are sufficient. So it ordered this hearing to discuss it and publicize it with the public community. And this is expected to take place next month.
All right, and you said that once that consultation process in October is completed, you said GCM is expected to be able to resume its activities in Zona Alta. Is that in the record? I don't recall reading this before.
No, it's just the normal process. It's our submission, because obviously it hasn't happened, but as part of the process, which is only a consultation, it is not expected that the consultation would result in a deprivation of its titles or anything. It's just that the consultation will be over, and the status quo before the judgment will resume.
So the consultation process would involve this one single meeting in October, and that completes the whole process, or is that just the first step in a multi-step process?
There's in judgment SU 133, there's a roadmap. In the dispositive, there's a roadmap of the consultation process. This is one of the steps in that process, but as we explained before, one of the main hurdles for the process moving forward was actually the question whether the report of the mayor was sufficient. So once this has been cleared, well, at least the ANMs of that has been cleared, the process will resume.
I'm pressing you on this. I recognize there's nothing in the record about this, so this is just your assertion, and we take this as just your assertion, but I want to make sure I understand what the assertion is. The assertion is that the process laid out by the court will essentially be complete after this one meeting scheduled for October?
No,
Okay,
that's
so what is exactly the assertion being made to us?
that the process will move forward after this, because
I know, but move forward over 10 years or be done? There's a very big difference between those two assertions. What are
Correct.
you asserting?
No, it's that the process will move way more quickly than it has up to this point, because the authorities in charge of implementing this are the national authorities, which have more capabilities for that process to move forward. As we have explained, the process was delayed in part because of the mayor of Marmato's difficulties in preparing this report. But now that it has been taken the view that the process is that the report is sufficient, the process is expected to move forward.
Okay, and is there this decision you've just referred to that that the authorities have now taken the position that the mayor's report is sufficient? Is that assessment itself in the record?
Yeah, it's in Exhibit R258. Yes.
Okay. Thank you. Sorry for all the interruptions.
Yes, there's a final point regarding why we submit that there has been no expropriation as a result of judgment SU-133 or its implementation. Contract CH 801 expires in 2032, and it can be extended for a similar term. So in that context, we submit that any difficulties in enjoying the rights arising from that are only temporary, and once the process is finalized, the claimant will be able to make use of its mining titles. And that concludes the submission of the facts. Thank you very much.
Good afternoon, members of the Tribunal. I will be addressing you in this final segment of this opening on international law and then damages. As my colleagues have shown on the facts, one of the fundamental deficiencies in this claim is that it is based on risks that were known, assumed, and indeed very much factored into the claimant's business model when it invested both at Segovia and at Marmato. And in our submission, it is an abuse of international law for Gran Colombia to now seek to use the FTA effectively as an insurance policy against those known risks. We haven't, contrary to what was suggested this morning, advanced this as a general defense of international law, but it's a principle that animates and comes in at different stages of the analysis with respect to both of the standards, the treaty provisions invoked by the claimant. And what I will address now is how that is, how they come in, and why the claimant's various submissions, which all go in one direction, are wrong. The suggestion that the circumstances and realities that were known and well understood by the investor at the time it made its investments are somehow legally irrelevant, should be ignored, and the tribunal should proceed on the fiction that none of that existed, and that this claimant somehow expected the evictions it now claims ought to have taken place. As this experienced tribunal knows, of course, a well-known phrase in the world of investment treaty arbitration is that BITs are not insurance policies against bad business decisions. The Maffezzini in Spain tribunal coined that and explained that BITs were never intended to be deemed to relieve investors of the business risks inherent in any investment. Indeed, what's very important for any tribunal to do is to inquire into the circumstances, including not only the facts surrounding the investment, but also the political, socioeconomic, cultural, historical conditions prevailing in the host state. That is a fundamental part of the inquiry, both, as we'll come on to see, in relation to the MST claim and also for the expropriation claim. And so we've set out on the slide here the India and Pakistan's tribunal's reference to the need to inquire into those circumstances. Counsel for the claimant this morning mentioned the Natterjee and Colombia case. That is a highly instructive case in our submission. It was decided last year. It's a case in which a claimant sought to hold Colombia liable under an investment treaty for what the tribunal found to be simply a reality of doing business in a different part of Colombia. The claimant had invested in the energy distribution sector in the Costa Caribe part of Colombia, where poverty and various issues meant that it was difficult to collect payment, and there were problems like electricity fraud, payment delinquency, and a history of poor relations between energy companies and the local community. And that investor knowingly invested, knowing of those risks, and the tribunal, unsurprisingly, came to the conclusion that all those issues were simply a reality of doing business, and that the claimant could not rely on the treaty effectively as an insurance policy against them. That's the Natterjee Award at RL 174. Now, turning to the treaty at hand and to how this principle applies in the context of the standards invoked by this claimant, a few words about this treaty. As the tribunal will know, it's a relatively recent treaty negotiated in the late 2000s, in which a number of important choices were made by the contracting states, by Canada and Colombia, in light of their various experiences and of course in light of the backlash against investment arbitration that had already arisen at that time, and certain controversial decisions which tribunals had adopted, in particular adopting overly expansive or unprincipled interpretations of the law. And to guard against that, a number of drafting choices were made, and also there's an important mechanism in the treaty by which Canada and Colombia have established a joint commission which can issue binding decisions on the interpretation of the treaty. Now, this is important in the context of the minimum standard of treatment claim, which I'll start out by addressing before turning to expropriation. For the MST claim, of course, as the tribunal knows, the standard under this treaty is the MST, the Customary International Law Minimum Standard. It's not the autonomous FET or FPS standards, and that's made crystal clear in Article 805. It's telling in our submission that the claimant had not pleaded a case by reference to this standard in its memorial. That shifted in its reply, but in its memorial it had addressed this as if the standard were not tied to customary international law. This treaty makes very clear also the importance of properly applying customary international law. It notes the importance of, in fact, it reminds tribunals of what customary international law is. It refers to international custom as evidence of a general state practice accepted as law. That's in footnote 2 to Article 805(1), and that's significant because the burden is on a claimant to adduce evidence of the rules of customary international law, to prove the rules of customary international law on which it relies, and the tribunal will find at RL 64 the decision of the Joint Commission between Canada and Colombia under this treaty, which again makes clear that the burden is on the claimant to prove those rules. And therefore, a claimant cannot simply plead a case by reference to prior tribunal awards. It was suggested this morning that it somehow could. Well, Canada and Colombia agree that is wrong. We can see, for instance, Canada's opinion expressed in its non-disputing party submission in the Bear Creek case at RL 147, in which it makes very clear that the decisions and awards of international courts and tribunals do not constitute instances of state practice for the purposes of proving the existence of a customary norm. And that has to be right. There is no such thing as an international common law of investment treaty awards. They do not create content of law. In its reply, after we pointed out that the claimant hadn't satisfied its burden of meeting the exacting MST standard in this treaty, GCM made an argument that it could somehow import broader standards through Article 804 of this treaty, the MFN provision. That is not something that is open to it to do under this treaty. Firstly, because the treaty makes very clear that the intention of the parties is very much to limit the standard, the customary international law standard, but secondly, the Joint Commission has in fact ruled on this specific point in a binding opinion in its decision number 6, RL 64. It made clear that for the purposes of Article 804, the MFN provision, substantive obligations of other international investment treaties and other trade agreements do not of themselves constitute treatment for the purpose of that article. And so the MFN argument is not open to the claimant to make here in our submission. Now, members of the tribunal, the threshold, of course, for finding a violation of the MST remains high. That is why the distinction is made in this treaty. The parties very much intended only to commit themselves to treat investors fairly and equitably and to accord them full protection and security insofar as that is required by the customary international law minimum standard. And so as contemporary tribunals have rightly found in interpreting that, something shocking and egregious is required, and the threshold remains high. We can see that is the position of Canada from its non-disputing party submission, for instance, in the ADF case, and so Canada and Colombia agree on this point too. I'll address the claims as the claimant has formulated them, firstly in relation to the FPS standard. Again, I'd make the point that in construing these standards, the tribunal must take account of the fact that the parties agreed to limit them.
I'm sorry, there's no state interpretation. No interpretación.
Is there interpretation now?
Okay.
Yes?
No estoy escuchando la interpretación. Ahora sí, sí. Yes. Go ahead.
Okay. I will carry on. I was just making the point that in relation to FPS and FET, the tribunal must apply the minimum standard and look for conduct that is shocking and egregious in order for those standards to be satisfied. But firstly, in relation to FPS, this morning, counsel for the claimant said they were not pursuing a claim for legal security. That must be right, and the Joint Commission...
Well, to be clear, they said they were not pursuing a claim for legal stability, meaning a change in law under full protection of security. But they did say they were pursuing a claim for legal security, which is different than legal stability. And I understood the claimant's case to be that that a state's obligation related to physical security includes not just the obligation of its police forces and so forth, but also the obligation of its judicial system to provide remedies. That was their argument. I'm curious your view of this.
Thank you, Madam. Well, the Joint Commission has certainly confirmed that the obligation relates to physical security of investors and covered investments.
Yeah, but looking at the quote from the Joint Commission, that sort of begs the question, because it says it refers to a party's obligations related to physical security. And so the question is, what are a party's obligations? Are the obligations just to bring out the police to prevent harm from occurring in the first place to physical security, or do the state's obligations also involve taking remedial action other than through the police, such as allowing judicial orders and so forth once physical security has been compromised? So I think the Joint Commission's statement that physical security is the issue here, not change in legislation or something, is taken. But the question is, what are the obligations?
Right. Absolutely, Madam, and that is what I will come on to right now. The obligation is one of reasonable diligence in the circumstances, and the claimant says it agrees that it's not an absolute obligation, but it says it's an objective one. And in our submission, the law is quite clear that it's an obligation that obliges states to use due diligence to prevent harassment and injuries to investors, and the diligence obligation is conditioned by the circumstances. And we can see this, for instance, in the Mamad Oil Award, CL 288, at paragraph 821.
I'm sorry to keep returning to this. I just want to get a clear answer, and I'm not understanding it. I understand your argument about the standard being reasonable diligence in the circumstances. My question is, by whom? Is it in your view, does full protection and security simply require that a state use its police forces, for example, reasonably diligently to prevent harm, or also does it require that the courts have a reasonably diligent manner of redress available? Telling me the standard doesn't tell me that.
It does not
apply to the courts?
It does not, madam. That would be conflating the FPS and the FET standards, and in our submission, the FPS standard really focuses on the obligation in relation to physical security, which generally would be provided by the army or the police that are charged by the state to serve that function. But I'd like to come back to you more fulsomely in relation to that.
Yeah, if you could, because obviously we've been shown some cases that talk about redress for events endangering physical security. Redress is after the effect, but is there no role under full protection and security for redress?
Well, we'll certainly come back to you, madam.
Okay.
Now, what is very important, certainly in relation to the interpretation of this standard, is the need to consider the circumstances prevailing at the time of the investment. And the tribunal will have seen, no doubt, an off-cited quote that Professors Paradell and Newcomb have coined, I believe, and it's been cited in Pantechniki, for instance, RL 110, paragraph 81. An investor investing in an area with endemic civil strife and poor governance cannot have the same expectation of physical security as one investing in London, New York, or Tokyo. And that is particularly apt in this case. The tribunal saw earlier, of course, the words of those in charge of the liquidation of Frontino given to the Congress in 2010, explaining why no one other than this unknown company called GCM was willing to take on these troubled assets, and the words used were, "It's not the same to exploit a gold mine in the province of Saskatchewan in Canada as in Segovia." And so in our submission, this notion is particularly important, and I'd like to refer the tribunal to the De Sutter and Madagascar Award at RL 171, which considered this particular question. It's a French language award rendered by Professor Kaufmann-Kohler with Alain Pellet and Carole Malinvaux. We've set out the English translation. There was also a dispute in that case where a claimant suggested that the FPS obligation ought to be taken in a manner that's divorced from any consideration of state resources, circumstances prevailing at the time of the investment, known risks, the role of the investor in the occurrence of the disturbances, and so forth. And so that tribunal said that it was undisputed from case law that indeed all of these circumstances must be taken into account. And as we've shown this morning, this claimant very much knew what it was investing in. It was investing in a problem. It assumed the risks for that problem, factored them into its business model, and is now seeking to hold the state liable as a result of the materialization of those risks. And in our submission, that is the fundamental reason why this FPS claim should be dismissed. In light of the prevailing circumstances and the way the state was addressing the issue of untitled artisanal and small-scale mining in Segovia and Marmato at the time, the claimant could not expect any different level of protection than what was given to it. And as we've also shown on the facts, when instances of particular disturbances caused by paros, which as we've shown were caused by the claimant itself, occurred, the state did act. It did not do nothing, as the claimant had suggested at the beginning of its opening. It did very much intervene. It mediated a solution. It sent in security forces where necessary and appropriate, and dealt with the issues. And likewise, as we've shown, the state has acted to deal with criminality linked to criminal organizations in an appropriate manner, and the tribunal will hear more from Mr. Chavez on that this week. Unless I can assist the tribunal further on FPS, I'll turn to FET. The claimant, of course, pleaded this through the full gamut of instances of conduct which some tribunals interpreting the autonomous FET standard have considered to accord with the ordinary meaning of the words unfair and
inequitable, but what the claimant hasn't shown is indeed that those instances of conduct form part of the minimum standard of treatment. And so if I start with legitimate expectations, which was the first claim pleaded by the claimant, the claimant alleged that the state has violated its expectations by failing to protect its titles from ASMs, by failing to evict them. And it also suggested that it had a legitimate expectation that a consultation would have already been conducted if necessary. The claim fails on the law, first of all, because the notion of protection of legitimate expectations does not form part of the minimum standard of treatment under customary international law. Canada and Colombia agree on that, as we can see from Canada's non-disputing party submissions in other cases, RL 91, RL 190, Bear Creek and Mesa Power, respectively. But in terms of the facts, having regard to all the circumstances here, there is no credible suggestion that this claimant expected any different treatments. It relies in its pleadings on various supposed representations made by Colombia, but as the questions from the tribunal this morning already elicited, there were no specific representations made to this claimant. It refers to things like road shows and various statements, but the tribunal will not be hearing from any witness, will not be seeing any documents in which the claimant proves any sort of reliance on any of those representations, which in any event suffer from the type of vagueness and generality which has led countless tribunals like White Industries to dismiss these sorts of attempts to rely on general and non-specific representations that fall far short of any sort of commitment. Next, I'm sorry, before I leave specific representations and legitimate expectations, in relation to the claim that there was an expectation that consultations would have been conducted prior to the agreement of the A&M for the assignment of the title, that is wrong, because judgment SU 133, as we've seen, is a judgment from Colombia's apex court, and the court did what apex courts do, which is to review the constitutionality of the executive branch. And so to the extent GCM had any expectations in relation to a potential review of the process, it could have expected nothing less. The Constitutional Court of Colombia is duly empowered, of course, to review decisions such as those made by the mining authorities, and that is what it did. Now, in relation to the claim that there was a lack of transparency, again, this doesn't form part of the customary international minimum standard. The claimant has adduced no evidence of that, and Canada also agrees with Colombia on this point, as we can see from the Bear Creek in Peru NDP submission as well. In any event, the claimant hasn't shown any lack of transparency in Colombia's conduct. The case it pleaded in relation to that, and its memorial centered around an allegation that permits for the discharge of tailings at the El Chocho facility had been delayed, but the claimant has made no serious showing of any shocking or egregious delays in that process, or indeed that there was any lack of transparency in it, and still less that any lack of transparency was prejudicial to the claimant in that process, or with respect to anything else that the claimant has pleaded. In our submission, the MST does not impose any duty to provide a stable legal and business environment. It is to be expected that the law will change over time. The law hasn't changed in this case. This is not a case of a change in law. Again, going back to what SU 133 did, it applied the Constitution, which of course exists since 1991 in Colombia and hasn't changed, guarantees the right of consultation, and of course ILO Convention 169 also adopted long before GCM's investment. And so this is not a case of a failure to provide stability. Likewise, with respect to the non-enforcement of amparos, we've shown you evidence that indeed amparos were not enforced before this claimant chose to invest, particularly at Frontino, and we've shown you the evidence of that on the record. And so again, no change here in anything. Moving on to arbitrariness, the claimant also cited the ICJ's decision in Elsie, which requires a showing of a willful disregard of due process of law, an act which shocks or at least surprises a sense of juridical propriety. In our submission, the claim is misconceived because the notion of arbitrariness doesn't just mean open to challenge, open to debate, unreasonable. The claimant has made arguments both in the SU-133 proceedings and in this arbitration as to why it disagrees with the Constitutional Court's approach. This tribunal is not a further court of appeal empowered to review that and consider what it considers to be reasonable. The standard is much higher than that, of course. Likewise, with respect to amparos and the approach the Colombian government has taken with respect to artisanal and small-scale miners, whether they're grouped in associations or not, the terminology really does not matter in our submission in this case. The fact is, all of these people in all of their forms were there in those forms when the claimant invested. There may have been further individuals who joined later on, but that's nothing unexpected. And the way Colombia has approached this problem in our submission is fully consistent with the approach, as we've shown, that the ILO, the IFC, the World Bank, the ICMM, so the mining industry, have urged states and the industry to adopt, which is to encourage a process of formalization over time in order for the operations of ASMs to be integrated in a mutually beneficial and socially responsible way. Turning to discrimination, again, not something that the claimant has shown forms part of this standard. The claimant hasn't made a claim for national treatment or most favored nations treatment, but it says discrimination forms part of the MST. Canada disagrees with that, as we can see from its NDP submission in Bear Creek, and so does Colombia. In any event, the claimant has made no showing of discrimination on these facts. The claimant, first of all, says that a military operation was conducted at Buritica, but not at Segovia and Marmato. As we've shown, the circumstances were very different. It hasn't begun to show that another investor was in like circumstances, suffered from differential treatment, and still less that there was any intention to discriminate by the authorities in Colombia. It also says that SU-133 was discriminatory because it somehow applied a rule that applied to no one else in relation to the need for a consultation. That is flawed for a number of reasons. One being that, as the Colombian Constitutional Court itself found, its decision was based on the particular circumstances of Marmato, which, as Mr. Mantilla Serrano and Mr. Romero explained earlier, were very particular indeed. Since the 1940s, the law, in fact, divided the two zones, and there were ASMs working in Zona Alta, and of course the court came to the view that the mere transfer of a title in circumstances in which this open pit project was being contemplated, requiring the displacement of the town. We saw a video in which that was already in motion, showed that there was indeed very much already an impact before the environmental licensing stage. That meant that a consultation was warranted. Now, what the claimant hasn't shown in order to make out its discrimination case is that another mining company was in the same position somewhere else in the same circumstances and was treated any differently. I'll now turn to denial of justice. It suggested, firstly, that SU-133 or the effect thereof is a denial of justice. It is not. A denial of justice, as this tribunal, of course, knows, requires a showing of a decision that is clearly improper and discreditable from a country's highest court, and that is not what SU-133 is. As Mr. Romero explained, it is in fact a properly considered, well-reasoned decision that applied the law properly, and certainly not in a way that was clearly improper and discreditable, so it doesn't meet that standard, even if there were cause to disagree with its reasoning, which there is not. And secondly, it's alleged that as the claimant puts it, the systemic non-processing of amparos is a denial of justice. It's not for a number of reasons, one of them being that the claimant has made the choice, in fact, not to take the issues it complains of here to Colombia's highest courts. As Mr. Romero explained, the issue concerning the non-enforcement of amparos for El Cogote was taken to the Antioquia Administrative Tribunal. It was then taken to the Appellate Tribunal in Antioquia, and Gran Colombia stopped there. It did not go further. Those tribunals came to well-reasoned decisions explaining that indeed the mayors had acted properly and lawfully in all the circumstances, having regard to the fact that there were public order considerations that were relevant to the mayor's decision-making, having regard to the fact that there were ongoing negotiations with the El Cogote Association, having regard to the fact of the history, the context, and the circumstances. And this claimant has chosen not to take that any further, and it cannot therefore assert a denial of justice claim in relation to the non-processing of amparos and the administrative decisions that were made in that regard. Members of the tribunal, unless I can assist further on the MST, I propose to move on to expropriation. Now, the expropriation claim, of course, it's an indirect expropriation claim. The claimant this morning addressed Annex 811. That was completely absent from its memorial. It had pleaded the case as a claim in which this guidance did not exist, and it referred to various decisions from tribunals applying the expropriation standard in different treaties. It is, of course, important for this tribunal to apply the guidance that is provided here in Annex 811 and to apply the factors properly. What the guidance tells the tribunal is to distinguish between what is and what isn't an indirect expropriation. It needs to conduct a fact-based inquiry, and the factors to be taken into account include the three that are set out, and then there's a codification of the police powers doctrine set out in Annex 811 to B as well, that is to be factored into the analysis. I'll start by taking the factors, by taking the first factor, which is the economic impact of the measure. Canada and Colombia agree that in considering this factor, a claimant needs to make a showing of a substantial deprivation of economic value, and that the mere interference with an investor's use of or enjoyment of the benefits associated with property is insufficient. Canada expressed that view in the Eco-Oro case in its non-disputing party submission RL 169, paragraph 17. And so that is what the claimant is required to prove. In addition, it's not sufficient for the claimant to point to a temporary impact on the on its economic rights or its ability to use its economic rights. I would refer the tribunal to the S.D. Myers Award, which considered that the mere delaying of an opportunity is not an expropriation case. Now, here, members of the tribunal, the claimant says that there comes a point where it no longer has access to its rights, and it has lost all of its rights, and that's sufficient for it to establish a case for expropriation. In our submission, that point clearly has not arisen. There has been no deprivation at present, because whilst the claimant submitted this claim in 2017 and argued before this tribunal in its pleadings that it had lost all of its rights in effect in the so-called affected area, it was publishing reports to the stock exchange saying that in fact it had resources in that area, and that indeed its qualified persons consultants, its mining consultants SRK, formed the view that there were reasonable prospects for eventual economic extraction. And so it was continuing to declare resources despite the fact that decision SU 133 had been issued in February 2017. In November 2017, it issues one report. It issues a revised report in 2019. It has not retracted those reports. And so as far as the stock market is concerned, it has those resources. They retain value. Another point to note is that GCM's own experts, in coming up with a conceptual plan for how GCM would have mined this area in the counterfactual that he posits, forecasts that by using the mechanized means at hand, it would take GCM until 2037 to mine the area out. And so clearly the artisanal and small-scale miners at Marmato have not mined out the area in the few years it has taken for the consultation process to progress. The claimant's own evidence is indeed that there are resources there that would take it to 2037 to mine. And so those resources are still there. Turning to the second factor that was addressed at length this morning by counsel for the claimant, the extent to which the measure or series of measures interfere with distinct, reasonable investment-backed expectations. This means what it says. The tribunal must conduct an inquiry into the extent to which the measures indeed interfere with what the claimant expected, and must consider whether those expectations were reasonable and whether they were distinct. Those words are not ambiguous. There's no need to have recourse to the travaux of this treaty, still less to trace the origins of the wording to the practice of the domestic courts of a third state. In our submission, that novel interpretation for which no authority was cited this morning is not one that this tribunal should follow, and there is no need, just as a matter of VCLT treaty interpretation for the tribunal to adopt such an interpretation, because the words are clear in our submission, and they very much militate in favor against a finding of expropriation here, because the facts are very clear that GCM simply could not have expected Colombia to evict the ASMs at Marmato, and indeed that was not its expectations. The facts are undisputed that GCM came in. You saw what was happening at Medoro. With Medoro, it started this open pit project. You saw its drilling manager speak to the local people, telling them that they would be displaced. GCM invested in that project by taking over Medoro, merging with it, and its plans were to carry on with that project. That's not disputed. And so its plans were to pay the people, to relocate them, and the assistance it expected from the government was in relation to the relocation process. There was no expectation of any enforcement of amparos or any military or police intervention in that process. That project was abandoned by GCM for reasons that are not related to anything that it alleges in this case. It's quite clear that the project was abandoned because gold prices fell, and that made the open pit project no longer economical, and because of the social opposition that the project faced. So again, by conducting analysis of what this investor actually expected, the tribunal must find that this factor really strongly militates against a finding of expropriation. And then finally, turning to the third factor, the character of the measures or series of measures, well, that calls for the tribunal to consider what type of measures we're considering, especially in light of paragraph B, which refers to the police powers doctrine, which calls on the tribunal to distinguish between good faith regulation for public purposes as opposed to something else which, in light of the evidence, cannot reasonably be viewed as having been taken in good faith. And as we've shown, the conduct at issue here is not discriminatory, and the mayors have acted for a public purpose to protect public safety and have sought to foster formalization as opposed to the mass eviction of the people who have lived and mined at Marmato for generations. In relation to deference, it was suggested this morning that there are limits to the degree of deference that tribunals must accord. That is true, and that is embodied in the language of paragraph 8112B, and Canada has explained in one of its non-disputing party submissions at RL 169 in the Eco-Oro case that indeed that language reflects that, the need for tribunals to accord deference to states in their determination of the level of protection they seek to achieve and the regulatory choices to achieve these objectives. Now here, Colombia has made the choice, A, to foster formalization, and B, to accord a right of consultation, and its constitutional court has made the choice, so to speak, to enforce those constitutional rights and require a consultation. And so in our submission, the character of the measures at issue, again, militates against the finding of indirect expropriation. Unless I can assist the tribunal further on the law, I'll go on to damages. So the tribunal heard very little about damages this morning, and that's very revealing in our submission. The tribunal will, of course, hear a lot from many experts this week, but it's telling in our submission that a presentation of the claims and the way they've been framed and constructed hasn't been made. And so that's what I'm going to do. I'm going to go through the claims that have been presented. I'm going to explain why the claimant hasn't met its burden of proof under international law. So I'll, as the tribunal may know, of course, from the pleadings, the largest claims are the Segovia stolen minerals claim for around $75 million of past losses and $37.5 million of future losses. So it's a lost profits claim, and I'll come on to explain what exactly it is in a moment and why there may be some confusion in the terminology, but in truth it is a lost profits claim to be proven to the standard required for that. And then the other large claim is the indirect expropriation claim at Marmato, which has been valued through a DCF, so again, one that is premised on projecting hypothetical lost profits. First, a few words about the tribunal's approach and the standards. The tribunal, of course, is familiar with the Chorzów principle, which is the starting point for any analysis of damages, and I turn to it despite it being very basic because the claimant's approach is inconsistent with that principle in several important respects. The tribunal's role, of course, is to re-establish the situation which would, in all probability, have existed if the wrongful act had not been committed. What that means, of course, is that the fact of loss must be proven to a high standard of factual certainty. And so the Bilcon Tribunal, for instance, in considering that issue, considered that indeed authorities in public international law require a high standard of factual certainty to prove a causal link between breach and injury. The alleged injury must in all probability have caused the breach, as in Chorzów, or there must be a conclusion with a sufficient degree of certainty that absent a breach, the injury would have been avoided, as in the genocide case. Here, what's important to bear in mind is that in relation to lost profits, the fact of loss, the loss that is alleged, is the lost profit. And so that is what needs to be proven to a high degree of factual certainty, the fact that those profits would, in the but-for world, have materialized in all probability to a high standard of factual certainty. And we can see that explained in the commentaries to the ILC articles. Comment 27 to Article 36 explains that lost profits have not been as commonly awarded in practice as compensation for accrued losses. Tribunals have been reluctant to provide compensation for claims with inherently speculative elements. And in our submission, that applies to the issue of loss causation. It also applies where a claimant chooses to use a discounted cash flow model, which is based on speculative assumptions. It's no good for the tribunal to point to cases suggesting that somehow the burden of proof should be relaxed because the fact of loss has been proven in expropriation cases through a showing of a taking, and thereafter anything goes in terms of a quantum analysis, the analysis of the quantification. If it's also based on a suggestion of lost profits, it also must be proven to a high standard in our submission. The next important point to bear in mind is that the claimant must show that its losses are not time-barred. As the tribunal knows, this FTA contains a 39-month time limit. Mining has been going on at Marmato for hundreds of years, and so the onus is on the claimant to show that the breaches and the losses it complains on, that the losses it complains of arise from breaches that are within the time bar. And here, as the tribunal identified this morning, of course, the cutoff date for claim is the 25th of February 2015. And in our submission, the claimant has not made a serious effort on the evidence to meet that burden in relation to a number of its losses. A further important point that derives both from the Chorzów standard and also this treaty is that the claimant has to show that its losses have arisen from actual treaty breaches. It's no good for the claimant to say that it anticipates that in the future there may be breaches of the treaty. The full reparation standard, the remedy of full reparation is to reestablish the situation which are the consequences of the legal act as if it had not been committed, past tense. And the tribunal only has jurisdiction under this treaty, under Article 819, to consider claims submitted by an investor where the investor's allegation is that the other party has breached, past tense, and the investor has incurred loss or damage by reason of or arising out of that breach. And so the claimant can't say, well, I expect in the future that the same conduct will continue, so there will be future breaches, so why don't I just have my damages now so that I don't have to bring another treaty claim if indeed I'm right on what I'm alleging. That's not something that is within the tribunal's jurisdiction to do. It would be wrong for that reason.
Which aspect of the claimant's damages case do you think is based on projections of future breaches?
Two of them, madam. First of all, most obviously, the stolen profits, the stolen minerals lost profits claim in relation to future losses. So what is this claim, to start off with? Well, it's a suggestion that in the future, ASMs, or illegal miners, as the claimant calls them, will continue to mine and therefore will continue to steal minerals, and therefore there will be foregone profits in the future. Again, that is an allegation that in the future the state will fail to protect in breach of international law by failing to enforce amparos and so forth at Segovia. And that, in our respectful submission, falls outside the tribunal's jurisdiction, and so the 37.5 million claim for those future losses falls away. The second claim, which in our submission also falls away on that basis, is the Marmato claim. Now, the claimant says it makes a claim for indirect expropriation and also breach of the MST, FET in relation to Marmato. It says it quantifies its losses in the same way. It says what it has lost is the fair market value at Marmato. As we've shown, the evidence shows that the resources are still there. And so what it is really saying is that in the future, if Colombia continues to fail to protect Marmato, if Colombia doesn't, after the consultation period is over, allow it back onto the title and confirm that it has rights to the title in question, then in the future it essentially will have been expropriated or will suffer breaches of the MST. The evidence shows that the resources are there for a long time in the future.
So, but what in effect are you saying that a party has to do in a situation where the claim is about uncertainty whether they'll get access back? Are you saying they have to wait till 2037 to see if they get it back? At that point, presumably, any claim is time barred. So, practically speaking, if you don't have an outright taking, you have a suspension pending some further activity. Does a claimant, investor in that circumstance, have to just wait indefinitely to see if the suspension is ever lifted?
No, madam. There's a consultation process that's ongoing, and the analysis, of course, depends on the circumstances of the particular case. In our submission on these facts, certainly the time hasn't come, and an important circumstance, what I'm pointing to here is in assessing how long is too long. It's important to have regard to the nature of the economic rights, and here the rights are to mine these minerals in this area, and there are sufficient minerals on the claimant's case for them to be mineable until 2037. And so in the meantime, what the claimant complains of is mining by artisanal and small-scale miners, who of course mine at a much slower rate. And so in our submission, all of this is relevant to, of course, the tribunal's analysis on the merits and the first factor of substantial deprivation. But to the extent this valuation is advanced as an appropriate one for an FET claim, in our submission, it's also essentially a claim for future breaches masquerading as a claim for the loss of a fair market value, which just hasn't been lost at present. And the fact that the claimant continues to issue reports after SU 133 to the stock market saying it believes it has reasonable prospects for eventual economic extraction for these minerals suggests that that is indeed the view the claimant has taken.
So, as I understand your answer, the tribunal should not simply decide that suspended operations for X years, whatever X is or is not too long, that the appropriateness of a suspension for X years has to be measured by whether the resources would be depleted in 1X, 2X, 3X, 4X years.
Absolutely, madam. And in addition to that, it's highly relevant in our submission that there was no suspension of operations here. There were no operations. That there was an abandoned open pit project in 2013, And there was no project when SU-133 came about. There had been no application for a license. What happened was in November, they came up with a resource estimate, so not declaring resources, so saying, okay, we think we could do an underground project. It requires contracting with the ASMs, just as we've done in Segovia. That is where they were. So again, another relevant circumstance for the tribunal to take into account for the expropriation analysis. And so that, in our submission, disposes of those claims. But there are other reasons why the claims are flawed, and I'm going to go through them in a moment now. A few words about the expert evidence that the tribunal will hear this week. You will hear from two very different experts. You will hear from Professor Graham Davis, an emeritus professor from the Colorado School of Mines on the respondent side, who is one of the world's leading authorities on mining valuation. On the claimant side, claimant has chosen to submit expert evidence from an economist who does not work in the mining industry, who has constructed a model for damages, which is based on a number of assumptions, as economists do. And if those assumptions are not true or not reasonable or realistic, then of course the validity of the model falls away. And it's very important in the world of mining valuation that mining valuations are based on realistic assumptions, otherwise they are speculative, and that is why it is an industry in which there are standards for valuation and in which standards are very much relevant. For example, in relation to the Marmato claim, where it's suggested that a DCF could be used even though that is not strictly compliant with the standards, well, the framework for considering that claim in this forum, of course, is the fair market value standard, which requires the tribunal to ask itself, what would a willing buyer acting reasonably pay for an asset? Well, a willing buyer in this industry would rely on the valuation of a qualified, suitably knowledgeable expert in this field. And that is not something that the tribunal has before it from the claimant's side. Now, in relation to these claims, I'll start with the Segovia stolen minerals claim for past losses. I said there was some confusion as to what exactly this is. It's sometimes presented in the claimant's pleadings as a claim for the value of stolen minerals. Sometimes it's accepted that it's for lost profits. It must be a claim for lost profits because it's not a suggestion that there was a pile of gold in a warehouse at Segovia and Marmato that people came and took, as in the case of the theft of assets as such. It's a claim of interference with minerals which only have value if indeed they can be mined economically, and so the value of the minerals is indeed the value of the profits to be derived. And so it is indeed a claim for lost profits, no matter how the claimant seeks to characterize it in various places. It's a claim which is premised on numerous assumptions which are to be proven to the requisite standards of proof for loss causation under international law. And I'm just going to take the tribunal through some of these assumptions. You'll, of course, hear from the experts further, and you already, of course, have expert reports that cover these issues. But let me just start with the first one. The first one is the assumption on the claimant's case that in the but-for world, the ASMs would not return or cause any disruption if Colombia had complied with its treaty obligations in the way that the claimant says that it should, by removing all these folks upon GCM's request, by following the amparo process as the claimant presented it this morning. That should be, the tribunal must ask itself, okay, what would happen in the but-for world? Would the ASMs be kept at bay as if a giant wall had been built around Segovia? Or would they not be very happy with what is happening to them? Would they return? Would they cause disruption? In our submission, the record amply supports the conclusion that in all probability they would return, they would cause disruption, they would not allow GCM to come in, evict them, and mine minerals over which they have a strong sense of ownership themselves. You'll have seen the non-disputing party submission from the El Cogote Association and the claims that are made there. Clearly, these ASMs have a strong perception that they have a right to be there, and so it's highly unlikely in our submission that they would simply go away, never to return, if Colombia had indeed complied with its obligations in the way that the claimant suggests that it should. Second assumption is that, but for the breaches, GCM would actually have mined the alleged stolen minerals. That's not a plausible assumption either. As the tribunal can imagine, ASMs tend to mine in a non-mechanized way, in a different way, and what they are mining is different. So the tribunal will know from the history of the Segovia project that Frontino had 3 main mines, and those are the ones that GCM mines. And then there are other mines. There are mines like El Cogote, and then there are a number of other mines which the claimant's expert divides between Tier 1 and Tier 2 mines. And those mines, on the claimant's expert's own case, are mines which provide lower grade materials, and so they aren't minerals that would have been suitable for mining in the main by GCM. And this is something, of course, that is disregarded in the claimant's case. Its assumption is that had the ASMs all been evicted, it would have been mining these at the same time and in the same amounts as the ASMs have mined them. It's not sufficient for the claimant to show that it could have done that in theory had it chosen to do that. What it needs to prove, as we've seen, is that in all probability that is what it would have done. Otherwise, it has not proven to the requisite standard that it has lost the profits that it claims. Third assumption, related to the first, is that indeed these would have been mineable at all, and in our submission, as Mr. Rossi will testify, he's an expert in mining engineering and mine planning and resource estimation, the assumption is unrealistic because GCM did not have the capacity to process the additional materials or to store the tailings, but even if it had that capacity, GCM itself doesn't choose to mine everything at once that it has. It starts by mining higher grade materials and then it moves on. And so that's illustrated, for instance, by one of GCM's mines called the Carla project, which GCM had in 2012. It declared resources for them in 2012. It didn't mine them until 2021. And so what that shows is that it's, again, unrealistic to assume that had these ASMs not been there from the start, GCM would have been mining everything that they actually mined over this period. Fourth assumption is that a number of additional costs wouldn't have been necessary had GCM mined these resources. GCM's experts assume that there would be no cost, for instance, for increasing the tailings storage facility. Again, that's not realistic, as the experts will testify, and likewise the assumption is made that processing the materials from the ASM mines would have been the same in its cost than the existing mines. Again, not technically realistic assumption. So for that reason, members of the tribunal, the stolen minerals claim should be dismissed. The claimant hasn't met its burden of proving that it lost the profits that it claims. The second category of losses that are claimed relate to the work stoppages, and essentially it's claimed that for each days of the strike, the GCM was unable, of the strikes and the work stoppages, GCM was prevented from mining. As we've seen, the claims fail on the merits because Colombia was in fact more than reasonably diligent in protecting GCM in each instance, and the events were in large part caused by GCM's attempts to evict the ASMs. But in any event, in terms of the quantification, it's also built around a number of assumptions. Essentially, what's suggested is that, first of all, the strikes would have ceased immediately had Colombia complied with its obligations. That's the basis for the model, and that conflicts with the claimant's own concession that indeed the FPS standard is not one that requires the state to prevent any disturbance. It requires it to act reasonably diligently. So even if the tribunal were to find that the state did not act diligently, it could not find that arose from its failure to not act immediately and prevent any of this from happening at all. The second assumption is that the work stoppages halted production completely during the full duration of the paros. They haven't proven that. The documents they rely on suggest that there was a slowdown for one of the paro, or there were just quote-unquote disruptions, but there's no proof that there was a complete halt of production. And then thirdly, the way the model is built, it compares the operating margin on the minerals in question at the time of the paros with what it would be in 2027. So the assumption is Gran Colombia is about to mine, a paro happens, they stop mining, and then they'll only come back to those minerals in 2027. That's not realistic. The reason the assumption is made is it suggested that it shifts the entire production cycle forward to 2027. But in truth, the reality is, of course, the minerals that were being mined will continue to be mined, and so the appropriate comparison would have been between what was being mined at the start of the paro, the operating margin at that time, and then at the end of the paro, the choice of 2027 is artificial. Third category of loss, infrastructure damage. This, again, is a bit of a misnomer because they're not claiming for the cost of damage to infrastructure. What they're saying is that they wasted expenditure exploring at an area at the Sandra K mine where they intercepted a tunnel with the La Rubiera mine. And they're saying that they went from level 3 of that mine to level 6, and when they got to level 6, they had to stop, and they'd wasted all their expenditure. They haven't wasted it. They explored levels 4 and 5, and in any event, La Rubiera has been there for many years, and they haven't proven that the loss that they claim of arises from a treaty breach that isn't time barred. And indeed, they were aware of La Rubiera as early as 2014 on their own evidence. A few words about the El Chocho tailing storage facility claim. This is only loosely connected to the main case that they've put forward. Essentially, they've said that there have been delays in permitting of their their permit applications to process materials, and it's delayed their plans to build the El Chocho tailing storage facility at Segovia. The expert reports address numerous deficiencies with this claim. I'll just briefly mention one, which disposes the entirety of the claim, is that the claimant has chosen to pursue this option for disposing of tailings. The evidence will show, and Mr. Rossi will testify, that it was perfectly possible for them to continue doing what Frontino did, which was to use the backfill method, essentially putting the tailings in tunnels that have been dug and that have been mined out. And all of this could have been avoided had GCM acted prudently as a mining operator. But there are many other flaws with the claim, which I won't get into now. I'll move on to the indirect expropriation claim. The valuation that has been put forward through the DCF presented by the claimant is simply absurd. One reason for that makes it very apparent is if one looks at the price paid for the Marmato affected area assets in 2011, and one takes the results of the valuation in 2017 presented by the claimants, one sees a threefold increase despite the fact that gold prices plummeted over this period, and so it's simply not credible to suggest that somehow this was such a great purchase that the valuation trebled over that time period of 6 years. Of course, one of the many reasons why the valuation is flawed is that it's not conducted in accordance with the appropriate method. It's a DCF. It relies on projected hypothetical lost profits, not appropriate for this type of property. Tribunal will be familiar, of course, with the usual skepticism that tribunals rightly adopt in approaching these claims, where it concerns an asset that has no history of production. This asset has no history of production as an underground mine. It previously was a series of small-scale mines and a series of titles that GCM purchased. And what industry guidance tells us is that for this type of property, mineral resource property, it's not appropriate to conduct a DCF where a large part of the resources are inferred mineral resources, and the tribunal will hear more from the experts on that and the application of the standards. I would just note that claimant's expert has chosen not to address the standards at all, not to try to explain, not to try to come up with a valuation that is consistent with the standards, and that's very telling in our submission. The valuation also assumes, it's slightly different, but it's the same assumption, that in the but-for world, a willing buyer looking at this asset would assume, okay, I'm going to consider how much I'm going to pay for this asset. I'm going to assume that Colombia complies with its treaty. So on the claimant's case, I'm going to assume that it's not going to issue decision SU-133, and I'm going to assume somehow that these ASMs are just going to leave and not going to cause any further disturbance. Again, that's something that this model assumes, and not a realistic assumption, not one that a willing, reasonable buyer at arm's length would make in relation to the so-called affected area in this case. There are numerous other flaws with the valuation, and the tribunal will hear from the experts in relation to this, but simply correcting for a number of very clear errors that are made, the valuation reduces by around 80%. Again, I won't go into the detail of what those are. The tribunal will hear from the experts on that. Finally, a few words about the alternative claim for around 259 million. It's called restitution. What it is, it's a suggestion that they should get their sunk costs plus a compound return. So it's asking the tribunal to assume that but for the breaches, they wouldn't have invested, and they would have invested in something else that would have been hugely profitable. In fact, they'd get an 8-fold increase in the price of what they paid for the Marmato acquisition. Again, not realistic, and it's wrong as a matter of principle. And so for those reasons, among many others, the tribunal should, if it gets the damages, dismiss these damages claims as unproven and flawed. In conclusion, members of the tribunal, accepting this claim, awarding damages here, would in our submission establish a precedent by which a mining company could come in, take on a risky project, knowing that it was its responsibility to work with ASMs and to deal with the circumstances it chooses to invest in, and then award compensation for that. Investment treaties are not insurance policies against known and assumed risks, and the tribunal shouldn't countenance here. And so unless we can assist the tribunal any further, those are our submissions.
Thank you very much. Questions for Council?
Yes, maybe. I'm reading a request for relief, and your first request is find that jurisdiction is lacking over all claims raised by GCM and dismiss all claims in their entirety and with prejudice. Unless I was really distracted, you have not pleaded anything on jurisdiction. Can you explain why?
This afternoon?
Yeah.
We haven't this afternoon. We've addressed it. We've certainly addressed it in our written submissions.
No, I know, but I'm a little bit surprised that you thought it was not important enough for you to discuss it.
It is absolutely important, madam. We were just on the limit, so we absolutely maintain our jurisdictional objections and would be happy to answer any questions in relation to them.
Well, maybe I will just ask you one question then. I have already touched on this issue with the counsel for the claimant this morning. I look at what you wrote, so I know you have also discussed it, in the rejoinder on the merits, in paragraph 241. You said multiple tribunals have held, well, first, I mean, for the record that we know where we are, of course, this will be a discussion of Article 821, where it said that you cannot bring you can only bring a claim if not more than 39 months have elapsed from the date on which the disputing investor first acquired or should have first acquired knowledge of the alleged breach and knowledge that the disputing investor has incurred loss or damage thereby. So you discuss this, and you say multiple tribunals have held that in case involving distinct and continuing breaches, the limitation period runs from the claimant's actual and constructive knowledge of the first breach. As the tribunal in Gran reasoned, the argument that limitation period stall for continuing breaches is unsustainable as it renders limitation periods redundant, and you cite Grand River, you cite Corona, etc. So can you be a little bit more elaborate on what conclusion you draw from this, especially in view of the fact that many, I think I counted them in between, 62 amparos requests were rejected, or if granted were not executed before the cutoff date in Segovia. What are your conclusions? Because it's not very clear. I mean, I didn't find it very clear, and as you did not discuss it, I would like you to be a little bit more explicit.
Thank you, Madam. Our conclusion and our submission is very much that these claims are time barred. This claimant invested in 2010, 2011, knowing already that amparos were not
So
being...
these claims, which ones?
So the claims in relation to the non-enforcement of amparos, that was, as you rightly identified, Madam, something that was happening both before the claimant invested, after it invested, before the time bar, February 2015, amparos were not being enforced. In our submission, what happened afterwards was simply a continuation of what was happening, nothing material changed. We accept, of course, decision SU 133 was rendered after the cutoff date for claims, and so to the extent the claimant, so any breaches associated with that are not time barred, but claims associated with the non-enforcement of amparos are time barred. But the claim that has been pleaded in relation to SU 133, it's a suggestion that its effect, coupled with the non-enforcement of amparos, is what constitutes the expropriation, and so in our submission it's also time barred for that reason, notwithstanding the fact that the judgment occurred later. What the claimant is truly complaining about and the loss that it claims to have suffered relates to the non-enforcement of amparos at Marmato.
Yeah, I had read this argument that the judgment of the Constitutional Court was linked with the amparo, but I didn't understand how it was linked. I mean, if you again could be a little more explicit, it would be helpful.
Certainly. So it's linked in two relevant ways for the purpose of this discussion. The first is it finds its origins in a challenge to the enforcement of amparos at Marmato, which occurred in 2015, and it's also linked on the claimant's own case when the claimant was asked, well, are you alleging that the decision is a denial of justice or an expropriation in of itself? It was said, and this is consistent with what has been pleaded, that it's the effect of it coupled with the non-enforcement of amparos which prevents the claimant from accessing its areas. And in our submission, the non-enforcement of amparos is a continuation of what was occurring before the cutoff date.
But, okay.
Did you have other questions?
No, but I was thinking, I mean, the judgment relates mainly to Marmato, and the amparos were mainly, I mean, the ones before, it was more in Segovia, so is there really a link?
There were amparos that were also at Marmato before the cutoff date, and we'd be happy to point you to those.
Not according to, I mean, in the list of amparos, it seems to me that maybe I should look at it better, that there were none before. But okay, I will check on that.
Madam, if I could also refer you to slide 41 of the claimant's opening, it presented the chronology of the background to decision SU 133, and what it shows is that it originates in the 2014-2015 Vilonsa eviction order, and so that was the genesis of the court proceeding, and the orders in question were from that time.
Because in Exhibit C69, the first amparo is 23/04/2015, which is after the cutoff date. But okay, I will.
Thank you, Madam. We'd like to come back to you on the evidence in relation to that.
Okay, that's it.
All right, I think this concludes the questions to the respondent and concludes the hearing day, unless the parties have any procedural matters that they wish to raise with us before we adjourn. For the claimant?
None for the claimant, Madam President.
And for the respondent?
We have none. Thank you, Madam President.
Thank you. What I will do, the tribunal, of course, has been active throughout both presentations. I will take a close look together with our tribunal secretary at the amount of time we have taken from both parties compared to what we anticipated we would do, and we'll make a appropriate judgment about the parties' time usage, netting out some tribunal time. I think you can trust us to apply our rule equally to both parties, and we will let you know what that comes to once I've looked at those numbers.
Indeed, Madam President. For the claimant, we would simply thank the tribunal for their questions. That's one of the main points from our perspective of getting together for a hearing, is to hear your questions, have an opportunity to think about them and provide answers. So thank you for them.
Thank you for appreciating our questions to you. Have a very good evening to all, and we will see you back here at 9 tomorrow with our first witness. Thank you.